Okay. Let's call this meeting to order. Sunshine Ordinance Task Force at 4:02 p.m. Call the roll.
Matthew Kate. Matthew Kate present. Lila Hood.
Present.
Lila Hood present. Josh Wolf. Not present. Rishi Chopra. Not present. Loam Tesfaye.
Present.
Present. Rodman Martin.
Present.
Rodman Martin present. Frank Canada.
Present.
Frank Canada present. Chris Highland. Not present. Matthew Yankee.
Present.
Matthew Yankee present. Fiona Hinsey. Not present.
You call me?
Chair Wolf.
Present.
Present.
Okay.
Agenda changes?
Yeah. Any changes, adjustments? Mention the agenda. I just want to publicly apologize to, I think it's William Clark, for their case. We had agreed at the last meeting that we would give the San Francisco Arts Commission an additional month to receive their advice letter from their legal counsel and that their item would be continued till today. That didn't happen. It was an oversight, and I'll take the responsibility for that. So I just wanted to notate that for the record. It will definitely be scheduled for next month, whether or not the Arts Commission gets that memo. Everybody else has delivered theirs, including our own legal counsel. Appreciate that. And so the case should proceed. Okay, any public comment on the agenda? Seeing no public comment, can we take that by acclamation? Seeing no objection, the agenda is approved.
I want to talk on the agenda
sure.
change.
I'm sorry.
Yeah, first item, Patrick Roddy. I have not been able to get in touch with him at all. I've emailed him. He has like 3 different emails. They all bounce back. I've tried to phone him. He has 2 phone numbers in his file. I tried those without any success of leaving a message. So I wanted to make that clear.
Are you saying that you're not sure if he's going to be here today?
Probably not.
Is Mr. Roddy here in the gallery? No. Okay. Okay. Well, then what we will need to do is we will table that item and then see if he shows. And if he doesn't, then we'll deal with it.
I actually suggest that I should write him a letter, draft a letter this coming week or early next week, saying that we have tabled his matter and that if he wishes to proceed, he has to let us know that he'd like to reopen.
Yeah, we could do that. Is this a continued item or is this first time?
No, this is a continued item.
Right. Okay. November 7th. Wow. Okay. All right, well, let's table it for now. Let's take it up towards the end of the meeting after we get through all the other cases, and we'll decide how to dispense with it at this point. I think the police department here?
Catherine
Oh, you
Hyland?
are. Okay. Oh, you are. Okay. I don't want to keep you here all day. I know you have a meeting going on next door. Do you have a second one here?
Yes, with Yolanda Jones versus Officer
Okay.
Rick Hitt. Yeah.
All right. Well, that's fine. All right. So let's table this, and then we'll get through public comment, and then we'll see what happens, and we can take it up then. Just in case there was a miscommunication, but all right. So we're looking for a motion to table item 18030.
So moved.
Moved by Member Canada, second by Member Kate. Is there any public comment on the tabling of this item? Seeing none, can we take that by acclamation? Great. Okay, then we can take the agenda by acclamation. No objection? Okay, great. Okay. Let's call next item.
Item number 4, file number 18093, complaint.
Minutes.
Minutes. Yeah.
Minutes, I apologize. Approval of the minutes of the Sunshine Ordinance Task Force, April 3rd, 2019 meeting.
Any changes, adjustments, comments on the minutes?
One very tiny typo. It was probably a spell check thing. Second paragraph from the bottom on page 4. It's where's W-E-A-R-S. It should be W-A-R-E-S.
Thank you, and thank you for reading the minutes so thoroughly.
Proof.
And what item was this?
This is item number 5. It's on page 4, second paragraph from the bottom. Artists make their wares. And it should be W-A-R-E-S.
Right.
Okay, anything else? Public comment on the minutes? Seeing no public comment, can we take? No, this is on the minutes from the last meeting. No, that was just a typographical error. So, so if please come up if you have comments on the minutes if there are other issues. Could you
And your name?
Pull the microphone down.
Pull the microphone to you.
hold on a second? I don't think that microphone's on.
So I had listened to the audio recording, but it wasn't until today that I found the meeting minutes. And I don't think it's clear what it says. Dave Tucker provided a summary of the complaint and requested the committee to find a violation. Later on, you say, let me see, I've got to find where. It's about the settlement agreement. It said that the requested the settlement agreement is being reviewed by the judge in the class action and cannot be provided until the class action suit is settled. So the settlement agreement, the OLSC settlement agreement, is not being reviewed by the Superior Court judge or the class counsel for the class action. So there's 2 settlement agreements. One settlement agreement is for the class action that's going through Superior Court. The settlement agreement that we requested was the settlement agreement between the Archdiocese and the OLSC that they're negotiating for the Archdiocese so the Archdiocese will have a global.
So let me ask, just for clarification,
Okay.
Are you making a correction based upon what happened at the last meeting, or are you giving us an update on?
No, it's not. Nothing's
Okay,
changed,
got it.
and there is an update, but I guess that has to be at the public comment time, right? But then, as I was reviewing this, I thought, well, this is not true because the settlement agreement. Mr. Mulligan stated that the requested settlement agreement is being reviewed by the judge, and that is not true. The requested settlement agreement, we are requesting a copy of any settlement agreement that the judge is reviewing is posted on the Superior Court website. So we have access to those.
So what should be? What are you saying
needs
should
to
be
take-
referenced?
Well, so this is what he said. So I don't know if you can change. But what he said is not true.
But that's of no consequence.
Yeah.
The minutes are just a recording of what happened at the meeting.
So then that would be later at the public
Yeah,
comment
you
time.
can make public comment and make a statement that what was
Okay.
said at the last meeting was not true, whatever
Okay, so
statement
it
is
ain't
that you want to say.
Okay, I'll just wait until later on.
Okay, great. Any other public comment on the minutes? Okay, seeing none, can we take that by acclamation? Okay. Did we get a motion? Did we get somebody to move it? No. Okay.
Move to approve the minutes.
Second.
So moved by Member Canada, second by Member Yankee. Okay. Now, can we take this by acclamation? Okay, thank you. Minutes are approved. Okay, let's call next item.
File number 18093, complaint filed by Yolanda Jones against Officer Rickiak and the Police Department for allegedly violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and or complete manner.
Okay, are both parties here? Okay, great. All right, just make yourself comfortable up front so it's easier for you to get up to the mic. We're going to get a brief from the committee that heard this. It was EOT.
I provided staff notes to everybody.
I saw, but good to have somebody.
I was at that one.
Iterate. Were you?
Yeah.
Can you explain?
Yeah, mainly the issue, if I recall correctly, it's been a few months, but it was regarding some logs of car washes that were destroyed. So the part of the request for these logs, and they weren't able to provide them because they had been subsequently destroyed.
Okay. All right. I guess we'll hear more of the detail in the presentation. Recognize Vice Chair Highland at 4:14. Yeah. Okay. So the complainant, the petitioner, Ms. Jones, you are first with 5 minutes. And let me just, for everybody's edification, let's just explain how this process works. We first have the petitioner or the complainant come up for 5 minutes. Then we ask for any additional parties for that any witnesses for that party. That's 5 minutes, and then we have the respondent, which is usually the city or city department or agency. They have 5 minutes, and then we'll ask for any witnesses on their behalf. Then the task force will take some time in getting clarifying questions. This will be the point where the task force tries to figure out what's happening, what's not happening, get clarification, so on and so forth. And then after all that happens, there'll be a 3-minute rebuttal for the respondent first and a 3-minute rebuttal for the petitioner. And then the task force will debate on the matter, and a motion will be put forward. And there'll either be an approval for an order of determination or to find no violation. Okay. Please start the clock.
Hi, excuse my voice. I'm Yolanda Jones, and basically we requested the car washing logs for the different vendors and the pricing, and we didn't receive those logs due to the fact that we got a response back saying that the logs were destroyed. So we were wondering if the logs were destroyed, the information on the log should have been input somewhere so we can find out what monies was spent with the different vendors at the time of the information that was on those logs before they were destroyed, so we can know where the city's monies went. And that's my 33 seconds, or 3 minutes.
Okay. Are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner? Seeing none, respondent?
Good evening, board members, or afternoon. Stephen Betts for the police department. Just briefly, what happened with this case is at the time for the logs that were requested, the department was between contracts with vendors. And so Officer Yick, who was in charge of payments and recording information for this, created a kind of an ad hoc system where he had his own personal log where he'd write down, X to this person, Y to that person, etc. When he was done with the month or whatever period of time it was for, he'd take the information, give it to fiscal. Fiscal then makes the payments. They record the receipts of to whom they paid and to how much they paid. After the payments were made, Officer Yick was, at some point, shortly thereafter, transferred out. He was promoted and transferred out. So the payments were made and records of who was paid what. He destroyed those logs because they were just for his own, kind of collating it to give it to fiscal. So the information exists. There's receipts from fiscal. It says who was paid what. But the logs that were requested, created by Officer Yick, do not exist anymore. So, and it's the department's position that these are the equivalent of a draft or memorandum because the purpose of them was for, and thus not required to be maintained, because the purpose was just for him to then tell fiscal, hey, pay these people, make the recordings, etc., which was done. The information exists. There are receipts that are readily available. I believe Ms. Johnson made a request last week or 2 weeks ago. We complied with it. We provided the information. It's just these draft logs no longer exist. So it's our request that this complaint be denied because there was no requirement to maintain the logs. We do have the information she asked, though, at the end of the day. That was ultimately provided as well. So, you have anything else to add, Lieutenant Wallen?
Yeah, I just wanted to add at the beginning, the request was not for the amount spent. It was merely for the logs. Once she clarified that she was interested in the amount spent, we provided that to her.
That it?
Stand on that.
Okay, thank you. Are any persons or witnesses provide any facts or evidence on behalf of the respondent?
No.
Okay, well, it's up to, public can step up and be party.
I'm sorry. I thought you were asking me if I had any.
No. No, if the public, somebody in the public domain wants to be party to your case, that's fine by us. Okay, members.
I have questions for the respondents, either one of you. So, even though the complainant specifically asked for the logs, what else is on the logs besides the financial information? I'm just trying to figure out why you just didn't give her the financials when she asked for the logs.
I think that we didn't give her. I think that the answer to that question is probably confusion on the part of the staff when she asked for logs instead of something like receipts or financial transaction. That's the only answer I can give you to that. I don't.
And how long from the point that she asked for the logs did she actually receive the financial information? What period of time?
I think she asked for the logs in April of about a year. April of last year, I think she made the request, or March, and she got this information last week.
Thank you.
When she made the second request.
Right. Thank you.
Don't leave. Go ahead.
So, and I just want to clarify that she's made a number of requests, and we've complied with all of them, and they've been fairly specific in nature. And so we're trying to really meet those requests. She is a vendor and familiar with the types of documents and has specific needs, and we've been trying to meet those. In this production, we did provide a large volume of emails that were requested, and the logs was a side item. And we've been trying to work with her, and once we established that this was a specific thing that she was interested in, we provided those documents.
Thank you.
Don't leave. I have a couple of questions. Mr. Betts, you had, what's your official title?
Legal counsel for the
Legal
Internal
counsel.
Affairs Division and Legal Division. Yeah.
Are you private, DCA? Are you at the city attorney's office?
I'm an attorney, but I'm not with the city attorney's office. I'm with the police department itself.
I see.
Staff
Okay.
attorney.
Can you spell your last name, please?
Sure. B as in boy, E-T-Z.
ETZ. Okay, thank you.
Okay, Mr. Betts. You testified that Officer Yix kept these logs more or less personally on his own, not on any city platform or document management system or what have you. But when he's done for, let's say, for whatever period he needs to report to fiscal, he sends that log to fiscal.
Yes.
What does fiscal do with those logs?
Do you know what do they do with it? Do you know how the information is transmitted? I don't know how the information is transmitted.
This was a temporary system for a specific time when there was no contract, so it's not a normal procedure that was in place.
That's not my question.
I know, but there's no standard answer because there wasn't a standard procedure for this period of time when the city was operating without a contract. So I don't have an answer to your question.
That's unresponsive to my question.
Yeah.
My question is, what does fiscal do with those logs when they get them?
So I
What did they do?
don't know if fiscal got an exact copy of the log part one. I don't know if they got an exact copy of the log. I don't know how the information was actually given to him.
Can you speak into the microphone, please?
You bet. I don't know exactly if he emailed. I don't think they emailed him the log. His response to us was, "I destroyed them. I don't have them." I don't know if he called them. He talked to somebody for this month. I don't know if he sent it in an email, wrote it out. I know that when they get the information, which I know is not what you're asking what they do with the logs. I know if when they get the information, they make the payments. They make their own records of the payments. So I can't answer your question because I don't know the answer.
Well, okay, because it's curious to me that you would just outright say that when he's done, he sends them to fiscal.
I should have said he sends the information. I don't know
Okay.
if he sent him the actual log. So
I see.
Yeah.
Okay. because we're looking for documents here. Okay,
Understood. So that was.
we're going to be picky.
So yeah, I get it.
Okay, great. Okay, my second question is what is the department's formal retention policy?
On this kind of document, I don't think there is one. There is no. We do have a retention policy that covers all sorts of different documents. I think I have this ancient thing from 1993 that lists out all different kinds of documents and how long they should be kept, and et cetera, et cetera. My review of this, as far as trying to find some kind of equivalent as far as notes and preparation for something, I don't think there is anything in this that says it shall be required. There are things about financial transactions and how long records of that would be kept. I think that would apply to the actual payments or receipts which do exist and which were disclosed. So.
Okay, thanks. Anybody else? Member Josh Wolf at 423.
Through the chair, I do have one more question.
Go ahead.
For the complainant, Ms. Jones? Have you received everything now that you asked for?
We have not. Only thing we have not received was the logs, but sorry. The only things we have not received were the logs, but the only question is the logs. The letter that we received, he didn't destroy them until he left the department. So we're just wondering. Okay, you kept them all the time that you were there, but the moment you transfer, you destroy them. So. We just want to know.
Mm-hmm. Okay, but you did get the information off that you would have gotten if you had received the physical log?
Yes.
Okay.
Just give me 1 second.
Sure.
This is Mr. Johnson.
Hi. So we still don't have all of the logs or
Speak up,
all
please.
we still don't have all of the logs, and we don't have any of the receipts and whatnot that we asked him for originally.
Can you state your name for the record?
Lamont Johnson.
Thank you.
So the
What logs did he
respondent stated that they provided the information that was in the logs through the receipts from their financial department.
No.
Ms. Jones, isn't that what?
That's why I had to get clarity, because we've got some recently, but that wasn't the ones from this time period that we requested for the logs. So we wanted it from.
We actually want it from March to March. So March of 2018 to March of 2019.
Okay.
We're now in May, so we missed April, and we still don't have those logs. So the police department hasn't been very forthright with producing these logs that they create.
Okay.
I just
hold
want him
on.
to repeat what he said. Can you repeat what period you wanted the logs
From
for?
March of 2018 to April of 2019.
Okay, because I was just looking at the request and it said I would like all car wash logs of vehicles within the last 60 days. And that was received in March 2018. So I thought that you wanted everything from January 2019 through
Right,
March.
that was one request of many.
Okay.
So we've been going through this for a while about the same issues.
That's what I was going to ask.
Yes.
Yeah,
Sure.
Vice Chair Howell.
I think I heard 13 total requests you've had.
Yes.
Okay.
Yes.
But what we're looking at is, I guess, the very first one,
Okay.
which it sounds like they've finally given you some information on last week. Is that, did I hear that correctly? And that's what we're trying to get to. How much of that first request
From
is
March 19th to 2018, 60 days prior to that date. No, I haven't received those.
okay? So we'd be talking February and March, basically, of 2018. That information you still don't have.
No.
Okay. I.e., the receipts and the financial transactions of those 2 months you don't have.
Right.
Okay.
So the respondent, what was provided?
They asked for
Microphone.
They asked for, in this last request that I referenced, a physical breakdown of how much money he has spent on car washing services and mobile from March 1st, 2018 to present. I'd also request a copy of April 2019 and May 2019. We provided them a log that we prepared from fiscal that it had the information for each month, how much was paid, the fiscal breakdown they asked for. It begins in March 1st and it ends in April 12th. And we told them in the response that the schedule for May 2019 is not available at this time. So I don't know if we're getting bogged in semantics here. They didn't get receipts. They didn't ask for receipts. They asked for the financial breakdown. We gave that to them. They have it. I think that's where we are right now.
Don't leave. A quick question. What was Officer Yick's official title for managing this?
I think it was just head of the fleet division.
He was an officer.
Yeah.
Officer.
Okay. That's all I have. Anybody else?
Yeah,
Member Yankee?
Yeah, for Mr. Betts. So just specifically, because it looks like the request was March 19th, 2018. So 6 days prior would be January 19th, 2018. So from January 19th, 2018 to March 19th, 2018, does she have the financials for that 60-day period?
I don't know. Did we
I-
say that?
Is that on there?
It's not on this most recent request. After last meeting, we discussed if there was something missing to try to specify requests. So, and there's been a lot of requests. I don't know if that was a subsequent request, but I'd be happy if they clarify.
I'm just looking. I'm looking at the,
Yeah, I mean,
the original one from 2018.
I don't have that. I don't have that with me. And if they
Okay.
say they haven't received it, and we need to clarify the request, but since it's not the actual physical logs, we're not able to provide that. If they would like to clarify that the document's similar to what we provided them for the subsequent time period, if that's what they would like, we'd be happy to work on that.
Okay.
Okay. So can we speak to the petitioner? So the type of information that you have, so you've received a type of information. Does that satisfy what you're looking for? And would that same type of information work for the earlier period that you are looking for information for?
Yes, if it has the vendor information on there from January 18 to March 18, that would work.
So did what you receive so far include the vendor information?
Yes, it has the vendors on there.
Okay, so it sounds like what we need is the documentation type that you have received that includes the vendor information, but for the months of January 2018 and February 2018. Or I guess January 18th through March 18th of 2019.
28.
Of 2018, okay.
Yes.
Do you want to ask the respondent? If
Sure.
they'd be willing?
Can the respondent come to the microphone and explain if they can provide that information and at what pace?
And then you folks asked.
Sorry, the petitioner. Sorry, I meant the petitioner.
I know, but you folks asked what Rick Yick's title was.
Oh,
He was a police fleet manager.
Okay, thank you.
I believe we would be able to provide that information, within a 10-day period if that's the information that they're seeking.
okay.
Okay, thank you. Anybody else? Member
Excuse
Kate?
me, just one more for the respondent. And this might be a little off topic from the complaint, but in looking at some of the records that were disclosed, there's email correspondence. I don't know if you have it in front of you, but page 187, for example, of our record, I see some redactions in the emails, and I don't think this is being brought up, but I'm just raising it because I'm curious where was the justification for those redactions shared with the requester, if they were at all.
Who's the question for?
For
For me?
Well,
I don't have
Or
the. I don't have the.
Sure. For the department that produced the records with redactions that, as far as I can tell, weren't justified.
In the cover
weren't
letter?
explained. The reason, the basis for the redactions hasn't been provided in the record that I've seen.
Okay.
And that's the question: is, am I missing that justification? And if I'm not, what was it?
Yeah, I agree. There are subject lines that are redacted, which is very curious to me. And there's nothing around investigation. It doesn't seem like it's trying to block out specific names of, like personal names or addresses or anything. So it does seem a little curious. You're right. It does seem a little curious to me. That would be a question for us, because if there's information that just in the interest of the public should have, there should be a reason why these were redacted, and who redacted them. It's really probably the better question. Do you know who redacted them?
I didn't have this question in advance, so I haven't had time to research that.
Okay.
Right. And and to the task force and to the respondent, I didn't mean to sandbag anybody or kind of bring something up that isn't even brought up by the complainant. It was just, as I was looking through, last night and even just now, seeing those. If nothing else, I just would want to suggest don't do that again. And the next time that there's a redaction, I mean, the ordinance requires and the state law requires that when you redact or withhold anything, that you've got to provide the justification. And if the justification was provided, I apologize, but in just what I'm looking at, I don't see the justification. And I would also, in what I'm looking at, be suspicious of the propriety of the justification. But I may be taking us down a rabbit hole that the complainant doesn't care about.
Looking at page 187, there's an individual called Lottie Baker that Rick Yick asks, did you redact this, that, and the other? And then some very interesting conversations that follow that, which is not part of this case. But
I would only say the only reason why it would be of any concern to us here today is that whether these documents already exist before they were submitted to us as redacted or unredacted. If they were specifically redacted to be submitted to us, then that would be a viable question to ask. If they existed currently in the record as being redacted, it's a different story, because somebody just pulls it out of a case file and submits it. It's already redacted for whatever reason it's redacted. So it is somewhat curious, as if whoever prepared. Do you know who prepared the documents that were sent to us?
I'm not sure which legal assistant prepared the documents. The documents that we provide to you are usually the documents that we have provided to the complainant. The only time I can recall redacting documents is if there was a medical issue. I think there was one time in the past when we had someone that had, as part of their request, submitted specific information that could compromise their medical privacy. I don't believe that's the case in this. As I said, there's a lot of documents, and since this wasn't a question that I had in advance, I haven't had a chance to research that. Our normal practice and procedure is to provide you the documents that were provided to the complainant in the manner that they were provided to the complainant, with the redactions that were provided to the complainant.
Yeah, just reading through some of this, it doesn't seem like any of that is applicable. I mean, it's talking about build-outs. Not too long ago, a discussion I had with you, I thought we discussed the blank being part of the spec build-out for these vehicles and future build-outs. I prepped the production team on these blank, but if this has changed, I would like to get this off the pipeline and back into inventory. Doesn't seem like anything dealing with personnel, contracting. It's not clear. And so my question would be is, if any of this information was applicable to those logs or that information, I think it would, we would have a little more standing on it. But I appreciate your admonishment, Member Kate, on that. But let me just take a crack at something just out of interest, if you don't mind, Ms. Jones. Was there any part of these documents that you, first of all, were any of the documents you received redacted?
Yes.
Okay. So so that means you received them before this case. You brought this case to us.
Yes.
Okay. So that answers that question. Do you feel that there's any information? I'm not asking the task force to take this up on issue. This is out of my own curiosity. Was there any information that was redacted that you feel would have revealed certain information that with respects that what you were looking for?
Yes.
And can you explain?
Well, what he's redacting is his actual activities during the day. So the person that redacted the documents is Brian Young, which is the fleet manager now.
Okay.
So he doesn't want us to know certain information, so he redacted it.
Okay. All right, thank you.
Okay.
And like I said, I'm not asking the task force to take up that action because it's not something that you brought up to us. We're asking for specific documents of which you did or did not receive, and that's what's before us today. Okay, thank you. All right, members, any other questions? Should we move to rebuttals? Okay, thank you very much. Police Department, you have the rebuttal first. If you have any rebuttals, 3 minutes.
I guess the only thing I'd like to state is that we are happy to work with the complainant to provide the information that they have stated that they needed, that was the basis for this complaint, which was, as they have stated today, financial information that states the name of the vendor that the monies were paid to. And we'd be happy to do that within 10 days and satisfy their request.
Ms. Jones, you have 3 minutes for rebuttal, if any.
Well, we requested all of this information because actually what's going on is the police department is selectively engaging in discrimination with these contracts and all of this information that you're
Could you lift the microphone up? Thank you.
All of this information that you're reading and the stuff in the emails all refer to these contracts. So that's what the basis of all the requests were. That's it.
Thank you. Okay, members. So the question before us is there a violation? And of what?
Certainly a timeliness one pops out, although you can argue it took them a while to work out what the requester was requesting, and sounds like they satisfied subsequent requests, but not the original one. So technically that one is still outstanding, and it's been over a year.
I guess one thing I'd like to know is at what point. I know that the initial documents that were requested had been destroyed, but why did it take so long to determine that the information they were looking for was available in another place? And why wasn't there more effort to determine that earlier?
Yeah, I think Chair Wolf asked that question. We didn't really get an answer to that as to how long did it take to actually get to that for the original request. And the original request is two parts. It's the logs, and then it's all the emails. I'm assuming they got the emails redacted or not, but not the logs. And then over time they worked out, oh, this is what you want from the logs. And looks like they sent a large batch of that recently, but not for the original 60 days. That's how I'm seeing it.
Well, what was testified, I think, before you walked in, was that the logs by Officer Yick were more or less kept to his person.
Heard that.
And then he destroyed them after he submitted them after some time. So the information was transmitted to the fiscal department, which then, paid the bills or whatever. So they have records of what they paid based upon those logs, and since then have recreated a kind of an activity log of those payments. So the petitioners have some of that or most of that.
Most of that, but not the original 60 days worth, it sounds like.
Right.
Once you could say they were in good faith trying to help get to the answer, and it took them a while to realize that's what you want. We can't give you this, but we can give you that. But just on paper, the original 60 days information from those logs is still outstanding. So, technically, I think we have to find a violation of timeliness, even though they're complying, and will do so in 10 days, just for the record.
I need to ask a clarifying question, if everybody doesn't mind me bringing up either party to answer this. Mr. Betts, the activity logs that Officer Yick was keeping, what was contained in those logs? Do you have any idea?
My understanding of what was contained in them, I've never seen them, obviously, but my understanding was X vendor is owed this amount. Y vendor is owed this amount for however many transactions, car transactions or whatever. That's what I think they contained.
Officer Whalen, do you have any additional information on that?
As I said before, the only reason the logs were being maintained was because there was a lapse in the contract. And I'm not sure exactly what information it contained, other than maybe the amount of times somebody visited a certain location. I don't know. I don't know how exactly the information was transmitted to fiscal. I just wanted to clarify that the original request didn't request the amount of money spent or the vendors. It was specific to the logs that no longer existed. So I just want to clarify that we never received a request for money, and we've been continuing to work with the requester, continuously throughout the year, and it wasn't made apparent to us that that was the specific thing that they were interested in.
So
this was an abnormal circumstance to be operating without a contract. I believe the company that had been doing the city car washes for at least 15 years, at least as long as I've, 20 years that I worked for the city, went out of business. So this was kind of just a stopgap measure. So I'm not sure. It wasn't a normal log that was maintained in the course of business.
So I'm a little more interested in activity other than payments. Activity logs can be all kinds of things.
Yeah, unfortunately, I can't speak to something that no longer exists and I've never seen. But if the information that they are interested in is indeed financial information and vendor information, we will make that information available to them now that has been clarified that that's the specific information that they're seeking.
I appreciate your looking to try and repair the problem. They're looking for specific information from a certain period of time in the past. So the reason why I'm asking this is because you've been talking about activity with regards to payments to certain vendors or contractors, and I'm now going to ask them if that was what they expected to get as part of an activity log. An activity log could be, what did Officer Yick do for the first hour in the morning?
Well, the request was not for an activity log. It was for car wash logs. There was no request for activity logs.
So how many cars were washed, that kind of thing?
I don't know what they expected to be on the logs, other than they asked for car wash logs that weren't maintained in the normal course of business and weren't retained.
Okay,
so.
let me ask them, because they obviously had some original idea what they were asking for. Go ahead.
I was asking for all activity that Rick Yick is engaged in. as it relates to conducting business for the city regarding the fleet. Any and everything that he's doing, I ask for, whether it's washing cars or buying cars or outfitting cars. I ask for everything.
Through the chair, do we have the original request in the package?
That's what I'm looking for.
We do. Hold on.
No, there's a,
It's page 61.
yeah.
There it is, okay.
I'll read it if you like. I would like a complete list of all emails, correspondence, text messages to and from Rick Yick, Mark Farley, and all staff in the Office of Contract Administration office in the last 60 days. I would like all car wash logs of vehicles within the last 60 days. And just to be clear, Mr. Johnson, did you get the list of that first part of it? Did you get the list of emails for those 60 days? Okay.
We didn't get just the information regarding the car.
The logs.
Logs. Okay, good. All right.
We didn't get the logs.
We're on the same page. Thank you.
So it's the car wash logs.
Right. So
Okay.
basically, we're trying to determine how many cars were washed per vendor and which vendors they were using at that time.
Okay, great. So it goes, you're looking for something more than just what the payments were to that vendor.
Right.
Okay. All right. Lieutenant Walland, do you know if, or Mr. Betts, do you know if any of that information exists?
Yeah. So in that log that I referenced before, that was eventually given to them, that was created afterward.
Right.
It has several columns. It's a voucher number, has the supplier name, which I think is the vendor, the date, the total, and the number of vehicles. So
Okay.
I do think, to answer your question earlier, what was on these logs, I think at least that information,
Okay.
how many units, that kind of stuff.
Right.
Other activity, it was a car wash log. I don't think there's anything else on there about his day-to-day activities, but that's my supposition. I don't know.
Okay, thank you. All right, members. Your motion.
Well, given that the information that they're asking for is still not been provided, I think I'll make a motion for timeliness, violation of timeliness, if nothing else.
Second that motion.
Okay, moved by Vice Chair Highland. So let's can we get a code number? 6721 what? 6721.
67.25, yeah.
25 is what I was going
For
to go
immediate
with.
disclosure.
Oh, is this an IDR?
Yeah.
Oh, okay. Oh, all right.
Looking at the document, it says you requested immediate disclosure.
Okay. All right. So moved by Vice Chair Highland, second by Member Tesfaye. To find violation of 6725 and timeliness. Any discussion or comment on that motion?
I have a question about it. Is it the January to March period we're talking about?
Yes.
2018. Okay.
You want it? Do you want that noted?
Just the original.
I think that might make sense if they've been complying.
Right.
they've
Just
been
the
in good
original
faith.
request.
Yeah, just that original request I think is outstanding.
Okay. Cheryl, if you can make sure that that gets included in the OD. Public comment on the motion, other than the parties. Seeing no public comment, please call the roll.
Member Highland?
Aye.
Member Highland, aye. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member J. Wolf?
Aye.
J. Wolf, aye. Member Kanata?
Aye.
Member Kanata, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Kate?
Aye.
Member Kate, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes.
Okay, thank you. We're approaching our 5 o'clock witching hour for public comment. But before that, let's, so we can release the respondents if necessary. I'm going to ask if Mr. Patrick Roddy is in the room. And he is not. So we've tabled this item. I'm going to take it from the table, and then let's discuss how we should dispense with this. This is the first item on the agenda.
Yeah, he wasn't at the November meeting either.
He wasn't at the November
That's why
meeting.
that's why it was continued. But at that one, he emailed a notification saying he was unavailable.
Okay.
We haven't gotten anything.
Since then.
Yeah.
Yep.
And I don't have anything personally to me, so.
Just to let you know, I emailed him Friday, Monday, and yesterday, and all those emails bounced back. And I tried to phone him, and I couldn't leave a message.
Wow. Okay.
Can we? I use the term close it.
Yeah, we have a process.
Until and if he wants to reopen it again.
Right. So we'll activate that process. Okay. All right. Great. So that dispenses with the first item. Thank you for your attendance. Free to go. All right. Let's. We can do one of two things. We can take if you want, we can continue and hold public comments right at 5 usually. Or 6 minutes to 5.
Well, why don't we?
Or do you want
the next one is a complaint by Denta Tedesse, and I don't see him here. So should we go down that path?
Except if he expected to come for it to be after public comment, he'd probably come after 5.
Okay.
I think if we open public comment, make sure we keep it open until after 5 in case someone walks into the room.
Okay, we can do that.
Okay.
All right. So we'll open the floor for public comment for the general public. Feel free to come up to the microphone. Clock.
So what's the time? 5 minutes? 3 minutes. Okay.
3 minutes.
So my comments are regarding the last month's hearing in which the motion to find the OLSC that they violated, the Sunshine Ordinance, it failed. And it failed, I think, based on Mr. Mulligan's statement that the class council was adamant about not having that document released. So Dave Tucker sent an email right after the meeting to the class council, who then responded back, "Dear David," and he actually copied this email to Pat Mulligan and Ken Walzak, the city attorney, and Bianca. And he said, "I repeat, I have never asked that the OLSC keep anything, let alone their settlement agreement with the Archdiocese, confidential. That is their decision alone, and I have no control over that process." So he completely denies the fact that he ever asked the OLSC to keep any of the documents. So the settlement agreement was one document requested by Dave. He requested numerous documents that we've been getting on a routine basis, and they just stopped. They just shut down because the OLSC chose to no longer share that information. So, and again, in the minutes, it says that the judge, at the preliminary hearing, it says, the minutes say the requested settlement agreement is being reviewed by the judge in the class action and cannot be provided until the class action suit is settled and released by the judge. But that is not true. The OLSC settlement agreement is not being reviewed by Judge Masula. And at the preliminary hearing at the Superior Court, Judge Masula said that she expected that class members would have access to the OLSC settlement agreement to review, and Adam Zappala, the class counsel, assured her that class members, all they needed to do was request it from the OLSC. But it's been denied. So we forwarded the message to Pat Mulligan. So I forwarded Adam's message to Pat Mulligan on Sunday, and I requested the settlement agreement. as a immediate disclosure request based on the fact that he had presented misinformation at this hearing. And actually, he did send it yesterday. So we have a copy of the settlement agreement. So my concern here is that he misrepresented the facts at the last hearing, that the motion failed because he misrepresented the facts at the last hearing, and we still haven't received any of the other documents that have been requested, and they've been delayed months and months and months because of the OLSC's refusal to provide these public documents. And so I guess I want to know what do we need to do from here? Can that be changed? You know, we still need verification that they are going to be required to provide us quickly with all the documents we've been waiting for months. Now that he's made it clear that they shouldn't have been.
So here's the thing. Our process is once a case has been adjudicated, whether there was a violation found or not found, there's a 60-day period of which any party can file for reconsideration of our decision.
Okay, so Dave needs to file.
If it's within 60 days of the order.
60 days. 60
days of our order.
Which was last month.
Right.
So he needs to file something quickly.
If he's interested, but it can only be done if there is new compelling evidence that would cause us, because we would first take up the issue of whether the new evidence compels for the case to be reopened.
So new compelling evidence like the fact that he gave us the settlement agreement and that
that's for you to determine. We can't determine that for you. You have to make that case to us.
Okay, so he would have to submit a new
Not new.
He'd have to send a claim, and it would come up at when? Like another month from now? It might come up for discussion again in another month?
We don't. Yeah, we'd have to look, and I'm not going to. It's kind of not appropriate during public comment to kind of do this kind of business. If Mr. Tucker is interested in filing for reconsideration, let that process happen, and then it becomes an administrative process. We'll take it from there. Okay.
Great. Thank you.
Thank you. Is there any other public comment? General public comment for items not on our agenda today. In the microphone, please.
Oh, yeah. Hi, my name is Sandra Weiss, and I'm on the agenda at the end. My email said 4 p.m. hearing, but it looks like on this agenda, my item is not going to be heard until at least 6 p.m. Is that correct? I'm just confirming that. It's 9, item 9?
Yeah, actually, your item 9, yes. And if you'll notice on the agenda, it says special order. The hearings on files number 18083 and 18089 will not begin earlier than 6 p.m.
Yes, I see that on the agenda. It's just that the email I received said 4 p.m. So
Yeah, I think the notice that you receive is just the time that the hearing starts. Our general meeting begins at 4 o'clock.
Okay. All right. Thank you.
Mm-hmm. Any other public comment? General public comment.
Hi, my name is Denta Tedessa, and this general public comment refers to how I'm being noticed for some of my complaints. On the complaint against the city attorney's office, file number 18010. It was changed. The named person was George Cothran. It was changed to just city attorney without my knowledge. It was then scheduled without my knowledge, just put on the agenda in terms of without giving me notice. I think that's improper. I should at least get notice saying that this is going to be on the particular agenda, because actually I thought that the SFMTA issue was going to be heard along with the two other ones, the sheriff's office and the city hall building management case. So the way that these complaints are being listed is a concern of mine. Also, the other one is that the January 2nd, 2019 complaint is completely gone. There's no audio. There's nothing mentioned in the summaries regarding that complaint. It's just simply gone for the record, and that's all I want to do. I want to come here with my complaints for the record, and when that is not in the record at all, it's an issue. Thank you.
He brought this up.
We'll discuss it later.
All right.
Okay. Let's get on with the rest of the agenda today.
Item number 6. Item number 6. 5.
We already did 5.
Public comment.
No. Oh.
Note sheet doesn't put that. It's the notes and the thing are different than that.
Okay.
Yeah.
File number 18011, complaint filed by Denta Tedeschi against John Haley and the San Francisco Municipal Transportation Agency for allegedly violating Administrative Code Section 6729-2 by failing to update the SFMTA website on a weekly basis.
Okay. This came through EOTC. This item was heard on November 17th, 2018. We moved to continue the matter.
Pending certain
and
questions.
The MTA was to provide responses with regards to the committee's questions. Did we get a response from them on that?
Yeah, there's a letter in the file. Yeah.
Okay. Member Josh Wolf.
Excuse me. As best I recall, this issue pertained to how policies were updated on the SMTA's website, in particular regarding cable cars and buses, and how that would govern Mr. Tedeschi's ability to work with his service dog on utilizing our public transit system. There was a question of when the actual policies had been put forward, and I don't really remember how we were able to take that apart, but whether or not the website itself is updated regularly was sort of an auxiliary point in Mr. Tedeschi's original complaint, but specifically was focused on the policy regarding cable cars and buses.
Through the chair. I think it's, if you go to page 309 in our packet, you will find their response to our specific questions. Or is it 301? Let me see. I think it's earlier, 301. So I guess since we've been through all the discovery, we can go right into the meat of this. Is that correct? So I would ask, is anyone from SFTMA here? Yes. Okay. Would you please approach?
Good afternoon. Roberta Boomer.
Hi, Roberta. How are you?
Hi. Well, thank you.
So bear with me 1 second here. I'm trying to find your memo here, your response. I'm sorry? No, these are questions. Because we've been through all that. Now we're kind of addressing their responses to our questions, correct?
Yeah, we're somewhat, I think we're before rebuttals, right?
And just to clarify, someone just
I don't believe this we've had a number of cases with this, with these parties, but I don't believe this. Is this the first time this item is before the full task force or
No.
not?
We heard in November 17th, 2018. Right.
Okay. Sorry, I was.
Right. So I think we're still in the discovery area before rebuttals.
And just a clarification, somebody mentioned that the complaint that the MTA failed to update the website on a weekly basis was auxiliary. It was not auxiliary. It was the complaint that it failed to update it. So I just wanted to make sure in the record that that's clear. Subsequent to that, and not part of the original complaint, the task force asked for additional information that wasn't part of the complainant's request or complaint with you. And we've provided you that information. But I just want to make sure that we keep the Mr. Tedesse's complaint separate from your subsequent questions.
Just to be clear, Ms. Boomer, we can always ask questions
Absolutely.
outside of what the petitioner brings to us, and sometimes we do. Sometimes we'll go past it and look
Absolutely.
for other violations.
And
so
no problem.
It was the tone of your response saying, "Well, we don't have to, but we're going to do this for you," that I didn't appreciate. So I want to set that tone to start, and then go forward from there. And actually, our very first question you still haven't answered, and that question is very simply: when policy is decided or changed, how soon does that get posted on the website? You kind of glossed over that very first question, so perhaps you can speak to that.
Okay. And I'm sorry if that was the tone that was picked up in your letter. That was certainly not the intention. All I was trying to do was to distinguish what Mr. Tedesse was complaining about from the questions that the SOTF had asked. So the first question was about how soon. And I am going to ask, do either of you want to? So I have two people here, one of them who manage our website, and then the other is the person who is in our Accessible Services Division who deals with operator bulletins and ADA issues. So, one of you gentlemen, thank you.
So the specific question.
I'm sorry.
My name is Dovid Copeland. I'm the digital communications coordinator for the agency.
Welcome.
Thank you. And just to clarify, the question that was asked is how long does it take before a policy is updated on the website? Is that correct?
Yeah.
My answer would probably say it really depends. We don't have I don't quite have enough background or understanding of the policy changes and how quickly they get to the website. There is a large staff at the agency that has access to updating the website. We do encourage everybody to keep the website content up to date, but I can't say that there's a hard and fast time frame that I can
Let me just
quote.
focus that question. So, members, take a look at bottom of page 299. Our first question reads as follows. SOTF requested a chronology of when the bulletin is approved and updated. If you go down to midway down 300, their answer number one, a chronology of when the bulletin is approved and updated. All it lists is, for instance, General Notice 2017-012, effective date and expiration date. That's not what we're asking. What we're interested in is the process of, when that policy changes, should there be any public noticing about that meetings? That's a whole other, and then when that becomes noticed, not when they're effective. So if someone could answer that specifically. So lead us through a day in the life of, a policy change, for instance.
I'll take a stab. I'm not sure if I can do. My name's Matt West. I'm with Accessible Services. My name's Matt West. I'm with Accessible Services. I guess the distinction to start off with is the notices themselves are primarily communications to operators. and we actually reissue those every year. They all expire December 31st, and we aim to get them reissued January 1st, so there's no discrepancy. So what you have here as far as the notices are the reissue dates of all those notices. I can just testify to in accessible services what we do is if we are changing a policy, when it officially gets signed and adopted, if it is a significant difference from what's already out there, we'll update the public accordingly. If it's something that's micro detailed to something that's really not a significant change, then we will leave it up. My understanding is it just kind of, like, can't think of a good example. Like fare policy, we would update the various fares, but we might still say you have to pay a fare unless we adopt a policy that no one has to pay a fare, in which case we would then do a bigger update that says now it's all free. So.
Okay, so these policies just typically will get refreshed at the beginning of the year, it looks like.
The actual notices, yes. The substance usually doesn't change.
Okay, but let's say substance changed in July. It would then get posted on your website and then posted again following January?
Depending. As I say, this is like, it's a bit out of my wheelhouse, but I just thought of a good example I think supports this is, for example, these notices are mainly at operators. So operators right now, they're like, I know there was a campaign about operators and cell phone use. Mm-hmm. So there was a big notice that said, hey, operators, these are the rules on cell phone use. Mm. I don't believe that was communicated to the public because it's really not intended for the public. But there are notices to operators. So if you asked for bulletins, you would get them. By the website, I don't think we provided any information saying, hi, public, we're...
Okay. And then if I could ask Mr. Tedeschi to approach for a second. And just to really kind of focus what your complaint is about here. This is not an ADA issue. This is really about them not updating their websites regarding accessibility, ADA, anything, whatever, in a timely basis. That's what this item is about, right?
Yes, this item is about there was absolutely no policy regarding the historic cable cars and its reference, its policy, specific SFMTA policy for having your service animal on your lap.
Okay.
It's a very specific thing.
So I took a look in the package and looked through those 4 years of their accessibility policy, and the language changes at some point.
Yes.
And then presumably that change language that says, yes, you do have to have the if you choose to sit outside, have the animal on your lap, goes into effect January 1st of 2016, I believe.
Yes, that's what I'm saying. That is fraud. That's absolutely, it did not happen. And the reason I say it's fraud is because the person that signed for John Haley is, I believe, Jeffrey Flynn, who also resigned from SFMTA. And I say that this policy was not there on 2016. Absolutely not. That's an outright lie. I will bet my life on it.
But your package shows that it was there.
I'm sorry?
The documents that you submitted to the screenshot showing that it is there.
No.
Am I misreading that?
No. So what you're talking about is in 2016, the policy about having your service animal on your lap did not exist. It changed on 2000 and it changed on the website 2017. January 6, 2017, that became live on the website.
Okay, so we're looking at in our package. This is page 300, and they've got their general notices, right?
Yeah.
And if you
those I've said are fraudulent. They're absolutely not true because they just have his signature. They have his signature on 2015. Notice how 2013, 2014, 2015, there's John Haley's signature. On 2016, it changes. Somebody for John Haley, and that's Jeffrey Flynn, who has resigned. I have found out has resigned, and I'm saying that is part of this whole fraud, because that lends. Either through the city attorney's office, they want to kind of absolve John Haley for that issue, or maybe he did. I don't know. But all I know is that the website was changed on January 6, 2017. The information that that SFMTA has provided for you in their packet shows that Mr. West changed it on 1/6/2017. It actually has the time. I think it's 2:35 p.m. or something like that. Mm-hmm. It says it right there. And so before that time, before that date, that policy was not in effect, period.
What policy was there? The one that had different language, it didn't include?
The one that had nothing to do with service animals being on your lap. It just said service animals must be under control. That's
under
it.
Control or under your legs? Or
under your legs, yes. Under your legs, on your lap, or out of the aisle. Those are the three places. And I had her between my legs, and that became an issue. And so when I put her on my lap, following this new policy, which I knew was fraudulent, then there's another issue came with these same particular drivers saying that they're afraid of her because he's operating the grip, and so he's afraid of my service animal because she's a pit bull. Okay. And so that's when all the discrediting me. Let
me pause there for a second.
Yeah.
Miss Boomer, if you could approach again. So in your response, you list a chronology and you reference these general notices
Yes.
on service animals, and you can go through and read those. But what we don't know is we have the general notice number. And I tried to put that general notice number on your website. It doesn't come up as a public document.
No.
So I can't see what it was. You've got the effective date, expiration date. But I guess the language of those general notices, I don't think it's in our packet. Is that something you can speak to, or is that something
I actually
we can
have that on May 25, 2017, there was a complaint 170058 that was heard by the Sunshine Ordinance Task Force alleging that Mr. Haley and Mr. Nolan failed to respond to a request for public records with regard to the service animal policy. As part of that packet, what was provided to the Sunshine Ordinance Task Force were the specific general notices. And what I have, for example, here, in 2013, the general notice reads, attention cable car operators when transporting a service animal. Service animals must be under the passenger's control at all times. For safety reasons, passengers with service animals must sit in the interior section with the animal on their lap or as far out of the aisle as possible. Mm-hmm. So it was clear at that time that service animals, gentlemen, correct me if I'm wrong, on cable cars must either sit interiorly or with the animal on the lap.
Okay, so I'm seeing up top of page 303, I'm actually seeing, as part of your response, you're listing the revision history and the language year to year. So I'm seeing that now, and it seems like, and just looking at the service animal policy, the riding outside on the lap language doesn't happen until 16 or 17. I'm going through 14.
Now, with respect to Mr. Tedessa's complaint, and just please be advised that or aware that Mr. Tedessa did bring this question questions about service animals on cable cars to our attention and to the attention of the Mayor's Office on Disability in July 27, 2016.
Right, that's a separate case. We're not. This is not an ADA issue. We are just really trying to keep it really tightly focused on, when that language went in and when it was noticed on the website.
All right.
So,
and the only point I was trying to make was that Mr. Tedesse had been provided with these policies in 2016 when staff rode with him. He was provided the policies multiple times.
So that's my question. So let's take a look. So according to your revision ID 231041 by Matthew West, 8614. Okay. And then that's bottom of page 307. And then we skip 3 years and we go to revision ID 439601 by Matthew West on 1617. And in that one, it does reference owner's lapse. What happened to the in-between notices? Did we not get that?
Actually, no.
Minus-
If you look at the top of page 308, the second to last bullet, service animals must ride on their owner's lap, under the owner's seat, or as far out of the aisle as possible.
Right. got
Animals
that.
may not occupy a seat.
Right. No, I see that. But that language, so according to this, that was.
It's the same language for that it maintains itself through 2017. According to
it starts in 2017, January 6, 2017, on page 308. But if you scroll back, the next revision update, which you'd think would be January 2016, is not here. It goes back to August of 14. So we're missing the updates there. Yeah, so I'd really like to see the revision update for January 6th of 2016, and just to see when that language, gets in there. Am I missing that? Because what you list in a table all the general notices, and it's year by year by year, and then you start to put the revision IDs, but you've skipped 15 and 16.
So there's a difference between the general bulletin that goes to operators and the website revisions.
Okay.
So these are the website revisions.
Right, so these would be available to the public. The ones that go to operators aren't available to the public, correct?
So what kind of happened is.
So hold on. Let me just interrupt you. So if I was a member of the general public, up until 2016, the language I would have seen, up until 2017, the language I would have seen regarding service animals would say, must be on leash, must be under control by their owners. And then, let's see, revision in August of 2014, must ride on the owner's lap, under the owner's seat, or as far out aisle as possible. Animals may not occupy a seat. Customers disruptive, destructive service animals may be asked to remove them from the vehicle. It's interesting that was added, but anyway. And then 14. Okay, so there's nothing about riding outside with your lap. That language doesn't happen until January of 2017.
So
Mr. Tedeschi's claimed that in 2016 that he was informed of this new policy and had many run-ins with you guys for a year is not supported by anything you've given us. So for 2016, your operators are operating under a directive that is not on your website. That's the crux of the matter.
So that's where I think so basically, try to go through this. So basically there's two things. The notice to operators, and what the notice to operators was mainly trying to do was clarify the existing policy. We've had an existing service animal policy that says service animals can ride on all Muni vehicles. They don't need to pay a fare. They can ride free of charge, any number, and then where they can ride. They're supposed to be on the person's lap, under their seat, or as far out of the aisle as possible. So prior to 2000, or on the website, what we told the public was basically that message. Get the bit.
So
8/6/2014, the revision ID, I guess it's 231041.
Yeah, I'll read it to you.
Yeah, on the second to last bullet point, it says service animals must ride on their owner's lap, under their owner's seat, or as far out of the aisle as possible.
Right.
Great.
Animals may not occupy a seat.
Right. Doesn't say anything about if someone chooses to ride on the outside, it must be on their lap. That doesn't happen on your website until January 2017.
And that's because this policy was Muni-wide. So all buses. What happened was on cable cars, if you ride on the exterior section, the bench is actually a solid piece of wood. There is no under the seat, and there's no aisle. So the assumption there was that if you don't have an aisle and you don't have a seat, don't have an aisle and don't have under the seat, then the only option left for a passenger.
Are your
to
feet
comply.
hanging off the seat in midair?
They hang off into, there's like a running board.
So there is something under your feet.
Not really under your, it's off.
It's
not,
small. I got
yeah,
it.
and it's not really an aisle. It's.
Okay.
It predates. I don't.
Right,
It's.
but an assumption's not a policy.
No, that's
the written policy doesn't come out until 2017 here.
No. So what I'm saying is on the web, because that was the thing. So when it became aware of, there's still confusion, we updated it to say, okay, we will do a specific call out for cable cars that says on cable cars.
Okay, so you just answered my question.
Yeah.
Until you made that specific call out, you had a general policy that did not specify that people had to sit on the outside if they chose to sit on the outside with the dog in their lap.
Yeah, and
that's not noticed anywhere. It's not on your website.
Yeah, it was mainly because we
that's what the petitioner is claiming, and you've just confirmed that for us. So thank you.
Okay.
That's it in a nutshell.
I also want to notate the first bullet under service animals on cable cars. It says service animals are encouraged to ride in the interior section of the cable car. And then the second book, it specifies the exterior sections. It really makes it difficult for people with disabilities to understand which is it? Is it a directive or is it a suggestion?
And what page are you on?
308 at the bottom.
Service animals on cable cars. You have two bullets.
Two bullets. And one says service animals are encouraged, and the other one says if riding on the exterior, service animals must be on the owner's lap. Let me ask you about that must be on the owner's lap. Was there any, who made that must? Who made that requirement?
It was our department talking with Transit about the safety concerns of what would happen. Is there any other safe place you can store an animal on the exterior of a cable car?
Let me ask you, for the rest of this policy, was this policy approved by the MTA board?
No.
This policy was not approved by the MTA board?
No.
How is it then valid?
So the MTA board, yes, is a policy body, but is not involved in the day-to-day operation of.
This is a system-wide policy for every single. No, I'm talking about the rest of it.
Yeah.
Everything above that. The pet policy, the service animal policy, and then you have service animals on cable cars. I mean, when you create a policy and you make addendums to the policy, that policy, if it was approved by the governing body or the policy body, must be approved.
Not all policies that have to do with operator behavior are brought to the MTA board. They are between the division and its employees.
So 1 month you can have it as it must be on their lap, and then the next month it could be they must be inside, and the next month it could be. I mean, you see where I'm going with this? It becomes very arbitrary for a very specific protected group.
Yes.
Protected. Yep. It's a protected class of people.
And as you can see with the policy history, there hasn't been that a lot of changes. The basic policy is that service animals will ride, and what we have tried to do, what Accessible Service has tried to do, is just make it clearer, so that when we are aware that it is confusing, that we clarify that so that resolves the confusion.
Okay, and I guess my last point before I let others continue is that notifying the drivers of a change in policy is not notifying the public. it's not really the driver's responsibility to do that.
And frankly, we have used the operator. Usually what happens is with cable cars, and Mr. West, you can speak to this, is that when somebody arrives with a service animal, the uniformed personnel will advise them then and there that here's the best place, the safest place for your animal to be. So that has always been the case, is the employees have done that. And so that's a standing item. I think the issue that is here is, okay, that happens at the moment of. What about before you arrive at that point?
That's right. So if somebody is arriving out of town with their service animal, they want to enjoy their family is sitting on the outside and they want to be there with them, kind of thing, right?
And through the chair. Yeah. Also, when it's the operator making the rider know these policies, all operators are different. One operator can say one thing and another operator can say another thing. To the example of somebody arriving from out of town, if they go to the website before 2017, they would have thought they could have ridden on the outside of the cable car with their service animal, not on their lap.
So that's part of why this approach was taken, is the policy we wanted to tell the public is it is your right to ride on any vehicle with a service animal. So that policy didn't change. We got questions from operators saying we have some concerns on this particular vehicle. What are our roles and responsibilities to do this? So we did a specific notice to operators. And since we have so many different vehicles and operators, kind of it's more letting them say, this is what you can do. It's up to you how you want to do it. Usually I tend not to try to advertise specific stuff because I don't want the message to be like, well, on the F car, you can only ride with this. On the, buses, only this. On rail, only this. It's more on Muni, you can ride with a service animal. Whoever you are, if you show up and get on Muni, you are guaranteed a ride with a service animal.
Yeah, but that's exactly what you have done 2017 onwards. So
what happened was it came to my attention that specific to cable cars, relying on the operator to say, excuse me, we'd like you to move back here, was still leading to some confusion. So it's the first time since I've been here that we've added a specific vehicle, okay, on cable cars, do this. Personally, it kind of goes, I'm a little nervous of doing it for every single vehicle because you start going down this very, I kind of agree with ideally it should be I arrive with a service animal and I can ride. I don't really want to.
Well, before I give it to Member Yankee, the one thing is with the ADA is that you really can't direct a person with a disability to where they are specifically supposed to sit, right?
Right.
So there comes that, unless it imposes a specific danger to them, right?
And that's why this one was, in the operator one, it was for the safety reasons.
I get that. I just want to say that out loud. Member Yankee.
I had a question for the complainant. So I believe the incident that you're referring to occurred in 2016, correct?
Yes.
So
I'm sorry.
Right. So
when you're saying incident, what do you mean?
Where you were confronted, it sounds like, on the cable car, and you said I think you ultimately suspended or something.
Yeah. The first time that happened was March of 17th, 2016.
Okay.
When I was taken off of handcuffs by a San Francisco police officer because I was riding on the outside of the cable car. I'm not talking about sitting down. I'm just talking about there are two different cable cars. There are cable cars that have the benches, and there are other ones that have kind of an enclosed space, but it's kind of outside of the inside carriage. I came on board, and she sat down right. She sat down, and the driver was afraid of her because she happens to be a pit bull, and so she then said, "You have to go. You have to get off." I said, "No, I have a right to ride the cable cars." At that time, Mr. West gave me this policy on paper this rider bulletin that they say that they only give to operators. No, he gave it to me to show that if I have any issues, because I had prior contact with Mr. West regarding my service animals on buses, not on cable cars yet, but on buses. And he gave me that piece of paper, and I was showing them. I said, look, this is a piece of paper that Mr. West gave me, saying that I can ride on the cable car anywhere as long as she's under control. And they refused. I actually offered to go inside. They called the cops. They called the supervisor. He said, I need to get out. I refused. I was placed under arrest, citizen's arrest, taken off the cable car. That started this whole process of me complaining and complaining and complaining.
Right. So what was I guess I'm asking, was the violation that you were told was that you did not have it on your lap?
No, at that time, for that March 17th one, I complained. I got a response from Virginia Rathke, senior transportation a person at SFMTA, saying she apologized. I have it's somewhere in the packet. She apologized for this happening. She said, I will resend this driver's bulletin again to all of them, just to remind them that the only requirement that you have your service animal on cable cars is that animal has to be under control. That's it. So I knew from that first complaint, from that response from SFMTA, for that March 17th complaint, that the only requirement for me to have for Rosie is to have her under control. He then came back from maternity leave, Mr. West did, in July. And all of a sudden I get a response from him for the same complaint that I already complained about on March 17th, saying this new policy, saying that, oh, you know what, you have to have your service animal on your lap. I said, wow, okay, fine, but please, can you make a reasonable accommodation? No response.
Okay, so it is the specific on the lap portion that they kept referring to you.
In July was the first time I've actually heard about it.
Right. Okay.
Again, referring to the same complaint I already heard from them back in March of 2016. I get the same response for the same complaint, which is a different version, on July 2016.
Right. Okay.
And then this time saying lab.
Right. So yeah, I obviously share the same concerns that have been brought up, that he keeps being communicated a policy that obviously isn't anywhere to be found on the website.
And I followed it.
And I think Member Kanata's point of when you deal with employees, oftentimes I think it's an absolutely valid question to ask, okay, well, where is that policy? I mean, where does it say I can't do that versus just an employee coming up with it? And looks like no place that references this anywhere except when our complainant was told it.
And then central to ADA is a reasonable accommodation. A reasonable accommodation is in place specifically to avoid these kind of issues down the line, somebody being discriminated against. So again, on the accommodation question, I'll follow it. I'll follow this new rule. I know it's wrong. I know it's never been there. I know you're trying to target me specifically. But you know what? I'll follow it because I'm a law-abiding person. But while I'm following it, can you please make a reasonable accommodation? Because she's 65 pounds. It's unsafe. I feel like it's unsafe for her to be on my lap on the cable car. She's safer between my legs. Now, on the cable car, there are two levels. There's one where you put your feet on, and then there's another level actually under that also where people hang out. You have 10-year-olds, 5-year-olds standing on the outside. Nothing's been said about that. There's no rule saying that you have to be under I don't know, 5 foot, whatever. There's no size requirements. There's no extra requirements for small kids to be hanging out. It's a risk. Transportation is inherently a risky thing. They cannot segregate me to go to a priority seating if I choose not to. This is an ADA law. They are not responsible for my safety. I'm responsible for my safety and the safety of my service animal. And when I've done everything that's humanly possible to mitigate this kind of issue, that then they ban me for 5 years from riding the cable cars. This whole thing goes to my housing. This whole thing goes. It's a simple thing. And Mr. Copeland also has testified that, yes, this policy was changed on 1/6/2017. He testified to that.
Thank you. So just, before we do rebuttals, I think the distinction between notices to operators and the distinction between updates to websites is an important one that we're on. The other one, which is maybe a larger issue, which I'm not sure we need to get into, is for these, system-wide policy changes, surely this goes before a body. They're noticed. There's public meetings. Public gets to comment on the changes. That's a whole road we haven't gone down, and it looks like it was just enacted without any of that. But I haven't done the research to know whether that's something we need to worry about in this case. But I think certainly there's some merit to this complaint that the policy, which operators have been operating on since August 6, 2014, for 2.5 years, is not anywhere on the website. And that's really the crux of the matter for me. So I certainly see a violation there. The question is, what is the violation? How do we package that? That's kind of where I'm
let's get back to the crux of the matter, which is the complaint brought to us was about the posting on the website, okay? And only to the detail that is distinctive between one period and another.
67.29-2.
Yep.
Okay.
Yeah. Okay. So let's try to keep it focused on that, because there are, Mr. Tedesca has a number of other cases that involve other aspects regarding to this. So let's try to keep this one to this point. Okay. Member.
Well, I think I would just like to express just a general frustration. I think everyone here is frustrated that if there's a policy change affecting riders that in a way they don't know about until an operator tells them without any documentation, it's a little irritating. And I think that's probably at the heart of what's going on here. And to update the website, I would think that'd be something you want to keep people updated about.
You can be a little flip about it. You can say, what if your property tax changed and nobody told you until you got the bill?
All right, but you imagine if you get on an airplane, there was no seatbelt sign, you would assume you don't have to wear your seatbelt, or, those things are informative. They help you kind of understand what the behavior will be, and if that's not there, it's not very helpful. And you think if there was a policy that involved where pets go or what you're allowed to do with them, that you'd want people to know that, and you wouldn't have to rely on a driver singling you out on a crowded bus or cable car trying to inform you at the time you're trying to go somewhere.
Member Josh Wolf.
I mean, I think that it's important that these sorts of updates get implemented sooner on the website than possible, or as soon as possible, and I don't believe that happened. But the general complaint of the website itself not being updated, I think that if you go to page wherever this begins, starting on page 312, I guess, you'll see that there definitely are various updates on an almost multiple times a week basis to the website itself. So I think that the generalized complaint of the website itself not being updated regularly has been unsubstantiated by these logs. The issue of this particular page being updated does concern me. From what I'm hearing of the MTA, essentially it is their opinion that this isn't a new policy so much as a clarification, because if the animal were on the outside, neither of the other places listed would really be applicable. It would not be possible, in their words, to have the animal on the side, on the aisle, or at a rider's feet. So I can certainly understand how their argument that this is a clarification and not a new policy makes sense. And so that's where I'm at in this matter at this point.
Okay, Member Hinsey.
And I just want to say that I walked in late, but that publicly that I do work with the folks at SFMTA Accessibility Services quite often in my job. I don't think it should impact my ability to rule in this case, although I did walk in the middle, so I may be abstaining since I haven't heard the arguments. But
Well, we don't do abstentions.
Yeah.
But this is a case has been continued from previous
it has,
times,
okay.
so we're just picking up in the
Oh, okay.
discovery area before rebuttals.
Okay, sounds good.
And just to recognize that that member Hinsey came in, I think, at 5:35.
5:30, yeah.
5:30. Okay, members, should we move to rebuttals? Okay. SFMTA, you have first crack at rebuttals, 3 minutes.
Thank you.
Please start, hold on, let me reset the clock.
So what is available online is our Accessible Services Guide that has been online since 2012. We also have available in print because many seniors are not as tech savvy as younger folks, me being one of them. In the Accessible Services Guide, it is very clear. The policy is that animals will ride on your lap and under your seat. In addition, what is available online is the operator's rule book. The operator's rule book is we take most of the policies, the operator's bulletins, and we compile them in a book that we distribute to operators, both on the rail side, on the bus side. That rule, with regard to accessibility of our vehicles, the rule book is available online. We do want you to know that our process does indeed involve, if it's going to impact passengers, we review the revisions with our Multimodal Accessibility Advisory Council, our Paratransit Coordinating Council. Depending upon the nature of the change, we do reach out to the Mayor's Office on Disabilities, Lighthouse for the Blind, the Independent Living Resource Center, Senior Disability Action. So we do reach out to them, to the public, to make sure that what we are doing is workable. Lastly, with regard to the bulletins, it is some of the bulletins are as simple as this weekend you've got the Haight Street Fair. We are rerouting the bus on these streets. Taking a document like that to our MTA board, who meets twice a month, is often problematic because a change sometimes has to happen and get implemented just like that. So it is they're just communications between management and staff. So we do post service impacts on our website for the public. It may look different than the bulletin, but it is available on the website. Lastly, as Mr. Tedesse just testified, he did receive the accurate policy, the 2016 policy, which says animals are required to place their service animals in their lap. He did receive that policy from Mr. West in July of 2017. In 2016, Mr. West rode with him on a cable car, talked to him about the way to ride in a safe manner, and then there were subsequent actions that resulted after that resulted in the revocation of his privileges, which is not the matter before you today. So, in any case, I'll shut up.
Thank you. Mr. Tedesse? Set the clock, please.
Okay, so again, this is not about the rule book being online. This is not about receiving the policy from Mr. West in 2016. This is not about Mr. West riding with me after I asked for a specific I asked him to actually come with me on a ride to see where I'm placing my service animal and tell me if that's wrong. That's not what this hearing is about. This hearing is about a specific thing that I complained about, that the website was not updated to reflect this particular policy of having a service animal on my lap in 2014, 15, 16. It was changed on 2017. So that is a failure of the website to being updated. 67.292 states each department is encouraged to make publicly available through its worldwide website as much information and as many documents as possible concerning its activities. Now, if you decide for them, that means you're telling me basically that that is not information that has anything to do with SFMTA's activities. You're telling me so basically that is the reason that they banned me for 5 years. You're telling me that means nothing. If you don't find in favor for me, you're basically saying that in your own complaint procedures, it says every single complaint that a petitioner brings forward to you will be looked upon in the most favorable way. I'm not a lawyer. I'm not a professional. I'm not an ADA expert. I do, though, am a person that is lawful. I follow the rules. I try as best to be as honest as I can be to you. So when I tell you that the service animal policy was not in effect for all those years, and it was only changed in 2017, January 6, 2017, you already have the testimony from Mr. Copeland saying that, yes, in fact, that was the change. I don't know what else to tell you. That is the website. It was not, that's it.
Thank you. Okay, members. Member LaHood.
So, yes, we can see that the website has been updated weekly and often has some new information, but this new information clearly does not include all information that's relevant to members of the public who are using MTA services. So saying that something or some version of a policy is available online is not the same as having complete information about policies that directly affect members of the public who are using the services. And I'm guessing, and others probably have more information about this, but that at the very least, maybe it should be posted in the vehicle rather than leaving it up to drivers. But that seems to not be adequate in terms of communicating policies to the public. And I understand the idea that general notices are often about schedule changes or employee behavior, but I think it's important for policies that directly affect the way members of the public use the system. Clearly, it's essential that those be available publicly online, more so than some of these other things that I think there's argument that every single general notice does not need to be posted online.
But I would say I ride the bus quite a bit, but the regular bus, and they make no bones about who gets to sit up in the front. And there's policy that's in, pretty big, that's there. There's lots of stickers that says priority seating. There's
good signage.
Yeah, there's and the policy itself. So, it's like it's good for one type of vehicle, but not for another, for the whole system, especially when you're making a specific rule. Essentially, now it says it must. Okay, for a particular vehicle, it should be posted on that vehicle, I would think. But we're not talking about what's posted on a vehicle. We're talking about the website here. So, sorry, Member Martin.
It's like I think the relevant portion of the ordinance, 67.
29-2.
29-2. I mean, I think this falls into each department is encouraged to make publicly available through its website as much information and as many documents as possible concerning its activities. I don't know where we can fall in the violation area, but an admonishment or a letter to the SFMTA saying, please post this stuff timely, because it's encouraged, it's not required, and that might be an issue. But it also might seem like Monday morning quarterbacking, but this is, people come from all over the country to ride these cable cars, and you'd think if there's something they'd want the public to know, it would be what they can and cannot do on the cable car, and where the animals can and cannot be. So I think the operator's manual and what the public knows, that's kind of talking past each other. I think there's stuff the public needs to know and policies that need to be at least provided to the public on an easily accessible basis. And whether that's something that changes in the future or now, I don't know.
Yeah, and further down in that paragraph, each department shall make reasonable efforts to ensure that the World Wide Web site is regularly reviewed for timeliness and updated on at least a weekly basis. And this is written 20 years ago, before these things are instantaneous. So that's actually quite a reasonable accommodation in this day and age. Just a quick point. I did go and look at the operator's manual. There is no language about riding on the lap. So your notice says one thing, your operator's manual says something, and then your website says something else. So that's not encouraging.
Through the chair. I just want to add to Member LaHood's statement. The fact that this policy was not put on until 2017, when it was being enforced earlier than that, to me is ridiculous, and I think there's a definite violation here.
Yeah, I just wanted to add to agree with Member Highland. I think that the portion talking about that the website's regularly reviewed for timeliness. Obviously, I think that's referring to things that are impactful to people, not like changing the graphics out or changing the font. That's not particularly updates that I think that this is speaking to. I think this is actually speaking to calling out timeliness, things that are important to the the general public.
I'm a little concerned as to the policy itself. Did the SFMTA Board of Directors give authority to specific department to make and adjust policies within this specific realm? This is not a simple matter in dealing with a protected class and a specific law that is specified for that class of people regarding accessibility. It kind of raises the bar up quite a bit for me, because I have to activate this law every time I ride the bus. I activate it for my own purposes.
That was the second part of what I was talking about. And was this part of a public meeting? Was it noticed? Was it discussed? Was there public comment? That whole line of reasoning.
Right. I can give you an example. I sometimes ride the SMART train up in Marin County, and they have quite a bit of space underneath their seating, and there's a big sign that says all service animals must be, scoot underneath the bench. I'm just paraphrasing. And then it shows the code number. And the conductor will come by and will tell you, can you scoot your dog underneath a little bit more? His tail is sticking out, or his foot is sticking out, or something like that. I get that for the purposes of the safety of everybody, that kind of thing. I get that part. But it's clearly posted, okay? And if I go on their website, it states that, because it's in their code. It's part of the ordinance that makes up the rules for riding their particular thing. So I'm a little concerned about. I don't know if this is diving in too deep on that part, because here you've got the question I have is this policy even valid at that point? So whether it's posted or not, is it really active? It's kind of it's a little bit difficult. I guess I would say is if assuming that it's active for whatever reason and whatever means, The question before us is whether it was posted appropriately so that the public can generally find it. And I think that's, to me, getting more closer to the question before us. And then the question is now, even though the what's being discussed here is in 67, 25.2, 29.2. If there is another, if you feel that there is another section of the code that this applies to, that's perfectly okay. That's our prerogative. If you see that there is a violation of the ordinance, up to you.
Such as?
I don't know. I'm
67.7, posting agenda, noticing that these changes.
No, 67.7 has to do with open meetings.
Okay.
It's not public records. But I hear where you're going.
Maybe that's something that the subcommittee like EOTC can follow up after this to kind of.
Well, let's get to get to the end of this first before we refer it to.
Well, that's easy. I can certainly put a 6729.2 violation. I can propose that, and then it can maybe.
Well, if you want to do it and try it and see what everybody feels, if there's more debate on that, then I've heard both sides. So
right. I'll propose a motion, a violation of 6729.2 for not noticing on the World Wide Web in a timely manner important policy changes.
I'll second.
So moved by Vice Chair Hyland, second by Member Kanata. Okay, debate.
Public comment.
Any debate? All right, so let's hear from the public. Any public comment? No public comment? Okay. Should we move to a vote?
Yeah.
Okay. Please call the roll.
Member Hyland?
Aye.
Member Hyland, aye. Member Kanata?
Aye.
Member Kanata, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member J. Wolf?
Aye.
Member J. Wolf, aye. Tesfaye has left.
Absent, yes, she's gone.
Yeah. Member LaHood?
Aye.
Member LaHood, aye. Member Kate?
No.
Member Kate, no. Member Hinsey?
Aye.
Member Hinsey, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes.
Okay.
Do we want to do anything else with?
Do you want to make a recommendation for it to be sent to committee, and for what? Is it something they can achieve?
The second piece of is this even valid? What was the process that went through?
That's not necessarily before us.
Mm-hmm.
That's a kind of a whole nother ball of wax. I would rather not, unless you individually want to have that researched.
And there's nothing that we can do in terms of compliance because it's already been done now in this particular instance, right?
It all depends upon what the results of that research might be. Whether you or the task force, or actually task force would want to communicate.
No, I think we've put our mark in the sand, and that's adequate at this point.
Okay.
For me.
Okay. Okay, that's it for this item. Thank you very much, parties, for attending. Let's call the next item.
Item number 7, file number 18067, complaint filed by Betty Mackey against the Treasure Island Development Authority for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and/or complete manner.
Are both parties here? Ms. Mackey?
Ms. Mackey informed me on Friday that she was unavailable for the hearing. This was the second time that we had noticed a hearing with her, and she said she was unavailable. She asked to be put on the June calendar. It was up to the chair, and I advised the member, Bob Beck, and Mr. Somerville to make an appearance.
All right, is Tida here? Okay, thank you. All right, members, so we have what should we do with the item at this point? Shall we table the item and notify the?
I mean, I think we should table it again because of the fact this is the second time the person has not showed up. And I mean, there's a responsibility if you put in a complaint and people are working on this complaint, you should be able to come to the meeting.
She had said in March, I got 2 emails from her in March asking that this particular item be put on the May agenda. And so when it was, she then said, I can't make it.
Okay. Yeah, member Rob.
Has respondent been here the entire time? Sorry. We can't care more about these than the complainants do. So
yeah. Yeah. Well, so let's have a motion to table the item.
You've got Member Wolf there.
Oh, I'm sorry, Member Joshua.
This might be not quite in the right place to it, but is it possible when we have been notified that one of the parties isn't going to be there to bring those up at the very beginning of the meeting so that?
Apologize.
Well, I'm not accusing. This is the practice we've done, and I'm just curious if we should have a practice of dealing with these.
We actually did do that at the beginning of the meeting.
We usually do agenda changes.
This particular item
just got
passed by
glanced
us.
over.
Yeah.
Okay, all right. Sorry, that was all I was.
All right.
So I'll move that we table this.
Is there a second?
I second.
Is there any public comment? Seeing none, let's call the roll on this, please. Substantive.
Member Kanata?
Aye.
Member Kanata, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member J. Wolf?
Aye.
Member J. Wolf, aye. Member Kate? Member Kate, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to table passes.
Okay, please call next item.
Okay.
Sorry?
For this item, on Thursday, the respondent, Fine Arts Museum, sent me their response and informed me that she couldn't make it to the hearing due to events that were taking place at the museum that she had to be part of. I asked her to send a representative, and she said nobody was available.
Okay, thank you. Did everybody get that? Okay.
Hear that?
And Mr. Smith is here.
Yeah. Did you hear that, Mr. Smith? Okay.
Repeat it for him.
Mr. Smith, for your item, I just wanted to say that on Thursday, the Fine Arts Museum submitted their response. I had asked Ms. Powers if she could send a representative because she said she would be unavailable, and she said nobody at the museum was available to attend tonight's hearing.
Yes, I knew that. Thank you. But their filing or submission was late, was tardy. You had said it was due the previous day, right?
Yes, I did.
So
And
they
I spoke
filed
to-
it late. Is it part of the record or not?
That's a good question.
They didn't meet your deadline.
It is part of the record. I published the agenda on Friday.
But I'm simply asking, they did not meet the deadline that you regularly set, which I observe. So have you received their submission or not?
Yes, I said I made it part of the packet.
So it's in our packet.
It's in our packet. So it arrived in time for it to be part of the packet. Okay.
Yeah, for
So yes, we received their communication in the appropriate time.
No, sorry, sir, but it was late.
When was it
Well,
late?
it was due on Thursday. You got it on Friday.
No, I got it on Thursday.
It's in our agenda packet.
So
It's in the agenda packet.
We got the packet. She got the thing on Thursday. We got the packet on Friday. So.
Right. The agenda is posted 3 days. The agenda gets posted 3 days in advance of the meeting. That's not the deadline for the.
No, the deadline is 5 days before, as I've come to learn. 5 business days before, and you set the deadline out in your communication to us, right? And I had communication with the clerk on this issue, which is the only reason I raise it, I don't really care. We can move
hold on a
on. But I was in communication with the clerk, and I asked the clerk when it was received, was it timely? And it wasn't. And I said, is it in the packet? And she said, ultimately, a day later, it would be up to the task force.
It's actually 5 calendar days, not 5 business days.
By calendar day.
Yeah.
Well, what you set out in the, one last detail, since this seems to have been going on for some time. What's given is a cutoff date, an actual date, which is the deadline, which is the date I'm referring to. The only point I wish to make is I don't care whether you see the submission or not. It's fine.
Okay.
But they couldn't even, in my mind, file it timely. That's all.
Appreciate it. Thank you.
That makes me sound crankier than
No,
I mean
it's
to
duly
be.
noted. I know. It's with respect.
apologize.
It's duly noted with respect.
All right. My turn. Is it?
Hold on. Let's get this rolling. And it's, okay. One thing I do want to state, and this was a little bit of lateness on my part. I received a communication from a member of the public who is here today, who was able to receive the information that Mr. Smith was not able to receive. He had sent it to us and had asked for it to be forwarded to everybody. I believe it was. But the question becomes is whether we can attach it as part of the record of this case.
Speak to that?
Sure.
Okay. I know the particular document you're talking
Sorry,
about.
I can't hear.
Speak in the mic.
Oh, sorry. I know the particular document you're talking about.
Can't hear you.
Is this better?
Yes.
Okay. I know the particular document you're talking about.
Uh-huh.
Ms. Powers did include it in her response.
Okay.
So I just wanted to point that out.
Okay, great. So now it's part of the record. Okay, let's, I just want to make sure everybody then is aware of that.
I believe it was included in her response.
Right, I didn't quite get that far down. Where does their section start? Respondent's response to complaint. Is that it? Page 870? 870, 8769. When you search in there, I don't find that person's name coming up. Okay, is that the document where? Okay, very good, and I'm sure we'll hear from that person too as we move along. Okay, so let's. Okay, did you call the item?
No, I haven't yet.
Okay, why don't you begin? Let's begin with that.
All right. Item number 8, file number 18083, complaint filed by Robert Smith against the Fine Arts Museums of San Francisco for allegedly violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and/or complete manner.
Okay, so just so to catch everybody up, on January 22nd, 2019, the complaint committee moved to find that the task force has jurisdiction, the requested records are public, and referred the matter to the task force for hearing. On March 6th, 2019, task force continued the matter, the call of the chair, and requested information from the city administrator regarding contractual relationship of the Fine Arts Foundation, the Corporation, the Fine Arts Museum, and the Fine Arts Museums of San Francisco. And that brings us to today. So I want to direct you to, I guess it's starting on page, as noted by our administrator, page 871, is a board resolution and a memorandum of understanding. So there's that part. And so we're picking this up after we had heard from both parties, and we are in the clarification discovery area. Okay. Yeah. Is the Fine Arts Museums here? No. Oh, no, they aren't. They aren't here. Right. That's right. So they aren't here. So how do we want to proceed? Proceed with them, without them?
I certainly hope, I would ask you proceed. I'm here. I'm ready to go. I'm the complainant.
I hear you. Member Martin, in the microphone, please.
Has anything happened since the last time we met with you? Has any documents been provided? Anything like that?
And
any positive developments?
Member Rodman's referring to another case, correct?
There are two different matters.
Oh, sorry. What's this? I
This
apologize.
this is very simple. This is a request for any documents relating to financial support for the exhibition from the Saudi government.
Has anything happened with that?
Oh.
It was Muslim.
Muslim nations, yeah.
Okay, so I've also got these a little mixed up. Okay, right. So the item that I was thinking about was the other item Mr. Smith has regarding to the relationships between those. This is not.
Yeah,
but these.
I believe it's the first time the task force has heard this.
Correct. So we need a full hearing then?
I don't understand the communication in that's on the
Sorry.
on the agenda.
I think the notes are off.
Because I thought we've already heard.
Yeah, you
this.
have. You did. March 6th. I apologize. March 6th, continue the matter to the call of the chair, and requesting what I believe was the document we were seeking information.
With regards to that. Okay, got it. Okay,
So
gotcha.
again, has anything been produced to you in the meantime, in the past 2 months?
Yes.
Yes.
I don't know about the 2-month marker. I'm trying to keep.
Well, about 50-something days.
Right. At some point, I was given a half dozen documents, none of which related to finances or financial support. I was given a copy of an invitation to a cocktail party held by someone and the director of the museum was invited. A few items like that. Nothing germane is the short answer.
So, just a moment. The memorandum of understanding that's included is not applicable to this case.
It is.
The memorandum of understanding
I'm
on
sorry,
page 871.
I don't mean to make their case, especially since they're not here. So I withdraw that.
Okay. So I'm reading this. This discusses the relationship between the three entities, which is a different case.
Different case, but I suppose supporting information for this.
So just to bring the task force up to speed, at the last
Compliance and amendments.
committee, we had both parties here. We asked them to give us a schedule of deliverables. to list what that was, right?
That's this one.
That's not this case. And that was where the 3 silos, all that's part of that. So just not to confuse. So
Not this case.
Right. So
Okay,
that's ongoing, and that's separate from all of this.
Member Josh Wolf, he's been waiting.
Sir?
I'm all ears.
I understand that you would like to get this cleared away today. And I see the potentiality for finding violations around the fact that they didn't send anyone to this meeting, possibly around documents you haven't yet received. But I'm curious whether your ultimate goal is to find a violation of the department or to get your records. And if your goal is to get your records, I see some advantage of going ahead and pushing this out until they're actually here, because we're not going to help get your records without having a conversation with the museum staff to work that through.
May I just do this brief summary that I brought with me, which may help make things clear? Would that be all right, or do you want me to respond directly to the question?
I'd love it if you could respond to the question first about whether you are seeking to find a violation or to get your records. Because if your goal is to just find a violation for possibly other external actions that are moving forward, I think we can possibly find that today. But if your goal through our body is to actually get the records, I'm not sure that not continuing isn't the best course of action.
Through the chair, real quick before you answer, the notes here state that the Fine Arts Museum contends that they've given the information. So I'm reading on the notes, and it says Melissa Powers provided a summary of the
page?
department. Oh, I'm on the administrator notes, page 8. Right. Okay. Melissa Powers, Fine Arts Museum, provided a summary of the department's position. She stated that the documents related to the exhibit have been produced to Mr. Smith and that there was very little to turn over. So have you gotten anything, I guess, is the question.
Well, let's go back, before Mr. Smith answers, let's go back to his original request. The request includes all documents, including electronic materials of any kind, however, and wherever stored or maintained, relating in any manner whatsoever to the subject matters described below, whenever created by whomever, in whatever fashion created in lieu of, okay.
Can I get a question from the complainant about, or an answer from the complainant about my question? Because
just a point of order. We are moving forward with this. Did we answer that or not?
Well, I think that the answer to my question would certainly help me decide whether or not we should move forward with it. I don't know about anyone else.
Specifically, he asked for all documents relating in any fashion, subsidies, gifts, travel, hotel charges, payments, so on, a long list, lent or supplied in any fashion to the King Abdulaziz Center for World Culture or any other Saudi entity, public or private, from January 1st, 2016 to the present. That's what he's asking for.
I understand that.
Okay.
My question, though, is if he's looking for a formalized violation, so for example, if he's pursuing this in an outside court, he could move forward once he gets that, or if he's looking for this body to help him get records that may exist.
We can't question his intent, right?
He can absolutely answer that if there's nothing wrong with me asking that, because it guides whether or not a continuance would make sense. I'm not asking what he's trying to do outside. I'm only asking whether he's interested in finding a violation or continuing to work with the department to get the records he seeks.
Okay.
That is the question that I'm asking.
Okay.
Can you answer that, sir?
Restated.
I'm a little lost because from my point of view, Mr. Wolf, I'm serious. They're not giving me the documents, and it's clear they aren't. The other Mr. Wolf was kind enough to read the request, which is very narrow. They haven't given me any such documents at all, but I would say in my summary that I learned from internet research that their docents were in Saudi Arabia, which they initially had denied. I want the documents, or I wouldn't be here. And indeed, not this, but this entire exercise has given me a much bigger story in my mind about the museums than I ever would have imagined when I began down this road. So, Do I want the documents? Yes. Do I want you to find that they have again violated the law? You bet. You have a city department, there's no question about that, violating the law. Do I wish you to find that they did so when they clearly, patently did so? Of course. They can't be scofflaws. And unfortunately, when I first came here at the beginning of this exercise, one of the panel asked Ms. Powers, the representative, whether she'd been trained in freedom of information. And she said she hadn't or had very little training. He then informed her not to worry, because even if you collectively made an order of determination that the museum had violated the law, which is what's involved, put as crisply as possible, it didn't matter. Life would go on. That troubled me. You issued that order. It's not true that it has no consequence for this particular institution, at any rate. It has a big consequence, potentially. I would like you, please, to do what is obvious and find that they have again violated the law, because in my judgment, respectfully, that has consequences as to that municipal entity. Yes is the answer to your question.
Thank you.
May I read my statement or not?
Well, this is a. So I'm a little confused. Is this a continued, or is this first time?
It's continued.
This is continued. Okay, so we've already been through the first part of the process, Mr. Smith. So we're just in the middle of trying to get more information, clarify whether the respondent has complied or not, and then make a determination.
Right. I was trying to aid you in that process.
I understand that. So we're not necessarily needing a new statement from you unless there's more information.
I believe the statement might assist you in that determination. That's up to you. I would earnestly ask you, having been here more times than I ever thought I would or wish to, I remain pursuing both of these matters, that you just listen to a 3-minute.
Okay, I would prefer that it would it be more appropriate for it to be considered a rebuttal?
I don't care what you denominate it, as long as I get to say it.
Because we have a specific, in our process, we have a rebuttal period of 3 minutes that provides you the opportunity to kind of provide a closing statement.
This thing, it means I'd give up 2 minutes of the 5.
All right, I'll put it to the task force, but I just remember Rodman
is the only thing that the Arts Museum provided the one-page MOU. Is that what they?
They provided a written response, which was included in the packet.
Yeah, it's on page.
What page?
Hold on, I just had it. It starts on page 866, and then on page 867 is their narrative.
Yeah, I mean, I think this is still hinging on whether they're considered an entity that's required to produce documents, public documents, and they're going to say no, whether they're here or not. I think we go forward today. I think we can listen to Mr. Smith again and make a decision. The museum gets money from the public, and I think that was a big question last time, was whether the ticket sales go to the city and who runs the museums, if I remember correctly.
I think, well...
Had the respondent acknowledged that revenue from admissions goes to exhibits? I am kind of perturbed that they're not here, and it's a big institution, and they can't send anybody.
They
So-
have 500 employees and $60 million. And this was said at 6 o'clock in the evening. They said they were busy and they couldn't spare anyone. What does that say about you and me?
Member Josh Wolf.
In basing this on what we've previously heard from both sides, I think there's definitely reason to find violation that we could do tonight and then refer this to compliance, or we could move the ball forward. Either way, the complainant is still seeking documents that exist. The agency is contending that they may not be impacted by the Sunshine Ordinance, or these documents may not exist. And so I really think the onus falls on us as to which is the better way to yield responsive action. Is it by finding a violation tonight and then leveraging our compliance and compliant amendments, process, or is it by waiting until they actually have both parties here and using the full task force to work through that dilemma?
I think they're just going to say they don't need to produce the documents and aren't going to produce them, no matter what we say here.
Mr. Martin?
I just think that's going to happen.
I think that's likely too.
Mr.
I'm
Smith,
just trying to understand which of those two forums is the best one to walk through that.
I think we would find the violation tonight and move it along.
That's pretty much what we've done with the other case. And in the other case, we got to that point. We got to compliance amendments. We gave them a schedule of deliverables, and we encouraged them to respond to his other requests, so they wouldn't have to go through this all over again. But that seems to be the only way to get them to produce anything. So I agree with you.
I would also just notate for the record that on page 869 at the bottom, it's a chronological responses by the respondent. On November 7th, 2018, states Ms. Powers provided records responsive to Mr. Smith's request as it relates to the museum and city employees. Is that part of this case? Or is that part?
I was just going to point out to you, they have now, thanks to your kind intervention and the law, produced not what they said they would, but a total of 11,000 documents. Now, if they seriously believe they are exempt from this statute, how did they give me 11,000 documents?
Thank you.
Those 11,000 were from the other case, not from this
from
Saudi
the other
case. Correct.
Right, and so, but they're in this chronology, it's within context of this particular, of your request regarding the King Abdulaziz Center of World Culture. So it's either they're mixing things up together, or I don't know. It's not clear to me.
If what you're saying, Mr. Wolf, is that they responded and gave me some documents which I've described tonight, that's correct. And of course, you make the point correctly. Why did they do that if they're claiming they're not compelled to?
So on page 870 is a list of all, quote, list of all relevant records with descriptions of documents provided. An email invitation with attachment to Director Hollain on behalf of King Abdulaziz Center World Culture to attend a private pre-opening, an email to Director Hollain to his assistant, an email exchanges between Director Hollain's assistant and a point of contact to the invitation. Did you receive all of these, Mr. Smith?
Those are the half dozen or whatever they are that I referred to earlier, the invitation to Mr. Hollain and so on.
Okay, so you did receive some documents regarding this?
The half dozen or so, yes, that I spoke about.
Okay, and are...
and they related to this, to the Saudi
right, and so they go on to say, number 3, search, date 2 says date relevant records provided to the complainant, November 7th, 2018. Then they say search conducted. ID department ran a search for all emails containing the terms of the center and or Edge of Arabia, which receives funding from the the King Abdulaziz Center from January 1st, 2016 to the present. 4, it is not disputed that COFAM employee was invited and hosted by the center on a delegation trip to Saudi Arabia.
Through the chair, that last point, number 4, was the whole crux of the other case where we basically ruled that we felt they were connected enough, the whole COFAM, the silo, and all that stuff, that they are obliged to produce documents. So that, again, they're dodging the bullet on that number 4, I believe. Sounds the same reasoning to me. So even right there is something that we would love to have in front of us and say, don't go down that road again.
Let's not conflate the two cases. If we can.
Well, I think you're reading this to suggest that they have satisfied his request and they have not.
No, I'm just stating what they have. I'm not inferring anything.
Okay.
I'm just stating this. I'm just reading back if people haven't received it, and for the benefit of people listening and here in the audience. And
through the chair, on top of 867, the respondent says they have initiated a renewed search for records.
You're right. Due to the prior commitments, Fine Arts Museum is not able to send a knowledgeable representative, blah, blah, blah. Okay. Right. Okay. So how do you want to proceed?
I agree that we should find a violation tonight and,
okay.
and go down the road of getting the records through compliance and amendments.
Let's give, first of all, let's call for rebuttals, okay? Because that's our process to kind of bring this thing to a close. I know Mr. Smith has something to say. Well, if it's not too much longer than our time frame, we can agree by a nod to extend it. Okay, how about this? How about we just extend rebuttals to 5 minutes? Okay, the respondent goes first. Is the respondent here? The respondent is not here, so we'll move to the complainant, Mr. Smith. 5 minutes. Can you please start the clock?
Thank you, sir.
Thank you.
I respectfully ask, refer this matter to the district attorney. Unfortunately, one of the, I told you about what was told to the museum's representative by somebody on the task force. I guess they're taking it at face value. I've told you what they've given me in terms of the Saudi material, which is nothing relating to finances. Why not? Their representative was sitting right here in front of you a few times. The easiest thing was for her to just say, we didn't get any. End of matter. She didn't do that. I asked the museum public relations person whether there was any Saudi support. She didn't answer, just didn't answer at all. So what could I do? I went the public PRR route. They said initially, we have no documents. I warned them that couldn't possibly be so, because a brief internet search showed that curators were in Saudi Arabia, presumably at Saudi expense, which it turns out thereafter they confirmed when I confronted them with it. Then, and only then, they said, that's right. So I expected documents. Since I had asked for financial documents, they gave me none. They said, again, docents are not city employees, which is, of course, not the test. And why did they produce all these documents if they truly believed their own position? Thousands of documents, and indeed they said that they had hired somebody to do it. Then I got the documents about a cocktail party. Tonight they're not here. The budget and employees I've told you about, they couldn't spare anybody. They're not taking this with any seriousness, even though it's a law. They sent me one document that had the name of somebody in contract with the museum. And they redacted the address and identifying materials of that person. So I did brief internet research, and what did it show? Who is this person? They're in contract with the city, for goodness sake. How can you redact their information? The answer is the person's in Qatar. So why are they resisting? Please, why? The answer is, as I repeat, I've now come to realize this is a much bigger story than when I began. Really, it is. You know, their tax records are public documents and are available. Obviously, they do fear somebody, and therefore they comply with some document requirements, the IRS and the Treasury Department in particular. So we know something about them. Why aren't they here? Not even on the phone. You give them the option to be on the phone. They can't pick up the telephone or the cell. There's got to be a reason. So what do you suppose it is? They have two lawyers, Lauren Curry, Lauren-Curry, in the city attorney's office, and Patrick Glenn, Glenn, a partner in the Hanson Bridget law firm. So they're not without counsel. So why are they not responding to you and to me? There can be only one reason, I respectfully submit, but it's common sense. I was talking to a Berkeley journalism student today, and I said, well, they're not responding. They're not here because if they're not here and they're not on the telephone, they don't have to answer any of your questions. And that's the simple truth of it. Der Tagesspiegel, German newspaper, said recently, a piece of art might not always be democratic, but a public institution can't be allowed to transform itself into a royal court. There is only one place this matter can be dealt with, has to be by law dealt with. It provides that it's the district attorney who exists to deal with matters like this, and I respectfully ask that you send the matter where it belongs. I know it's unusual, but this matter, if not unusual, is nothing else. This is a public institution, and it's completely violating the law. Thank you.
Thank you. Okay, members. Is there a motion?
I think we should find violation on 6721A and maybe other things for not providing information. And I don't know the section, but for not sending a knowledgeable representative also.
Is that a motion?
Yeah.
Yeah, that's a motion.
I'll second.
Okay, I'm just trying to find the code.
Yeah, I
for
will.
the-
Code for the representative and knowledgeable representative.
Yeah. I think it's 6721. E, an authorized representative of the custodian of public records shall request, oh no. Maybe that is the one. A public hearing records not. An authorized representative of the custodian of public records requested shall attend any hearing and explain the basis for its decision to withhold the records requested.
And what is that
the
one?
6721E, the
Okay,
last
so-
sentence.
So A and E.
A&E, okay. All right, any other comments, discussion on the motion? Member Martin.
Okay, restate the motion.
Since you brought it up, does anyone want to weigh in on what is on his proposal to send it to the district attorney? I kind of want to give him a response.
Okay.
I'm open to that. I don't know if it's at this stage. It might be sent to compliance, it sounds like, as the next step. Go ahead. Sorry, Member Wolf. Yeah, I just wanted to bring it up.
I think there's potentially some merit in moving forward and sending it to the district attorney, but I don't feel comfortable doing so at the meeting that the other party had requested a continuance for, which was sort of the heart of where I was coming from earlier. So I think that in terms of the course to consider that, we should go to compliance, and then if it looks like compliance can send it back to us with that recommendation.
Okay.
I'm fine with that.
Okay. Everybody? All right. Okay. Public comment on the motion.
Good evening, Ted. Am I on?
Yes, you are.
Okay. Good evening, task force members. My name's Richard Nee. I have to caution you that I am not an attorney. However, I did spend 12 years on the task force. My knowledge of sunshine law is fairly comprehensive. Not necessarily that it has to do with this complaint. It might have to do with the other one, but maybe. In the copy that I forwarded to you of the board resolution and the MOU, there may be a misprint, and I think it might go to the question of jurisdiction on this whole matter, whether COFAM and FAMF would be under the jurisdiction of the Sunshine Ordinance. In the very last paragraph, second sentence, it says the COFAM bylaws proscribe that the Board of Trustees consists of the combined boards of FAMSF and FAMF and others as designated by the FAMSF Board of Trustees. And I'm wondering if proscribe should be prescribe. Proscribe means forbid. So that might be something that you would want to check into, particularly with the city attorney, with the entities themselves, and with the city administrative officer whom you have asked to analyze the contractual relationship among the three entities. In terms of whether to act on this tonight, yeah, I believe you should. With all respect to the concerns that member Josh Wolf has raised, I still think that you need to move this forward. You need to apply that pressure. And in terms of where to send it beyond this, whether it's to the DA or perhaps ethics, the DA, when I was on the task force, the DA would typically respond to referrals by saying, well, we get involved only if we see there's evidence of possible criminal activity, and this doesn't meet that criterion. So, you could send it to the DA now, but, you might get that same response. You may have evidence of willful violation here, which ethics would certainly want to know about. If this were a court of law, the respondents could not say, oh, well, we got other things to do, we can't show up.
Thank you, former member Nee. Any other public comment? Seeing none, shall we vote? Please call the roll. Kanata.
Yeah, I know. Member Kanata?
Aye.
Member Kanata, aye. Member Hensy?
Aye.
Member Hensy, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member Wolf?
Aye.
Member Wolf, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Kate? Member Kate, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes.
And this will be referred to compliance and amendments for monitoring. And please do keep us posted, obviously. Okay, let's call the next item.
Item number 9, file number 18095, complaint filed by Sandra Weiss against Kevin Guy and the Office of Short-Term Rentals for allegedly violating Administrative Code, Section 6721, by failing to respond to an immediate disclosure request in a timely and/or complete manner.
Okay. Through the chair, for the purposes of transparency, I know Mr. Guy from his time in the planning department and tons of work on Polk Street in my neighborhood, but it will not affect my impartiality.
Okay.
Likewise, I know Mr. Guy at OSTR, and I think I can still be impartial.
You think, or you know?
I know.
Okay. All right. Both parties here? Yes. Okay, great. Complaint committee? Want to give a brief? Yeah.
What was the last one? 'Cause
we give the complaint committee an opportunity to give a brief to the full task force before we begin the proceedings. If there is any.
Who's on that committee? Member Tesfaye, Member Martin, and Member Kate.
Yeah,
Petitioner, you weren't there that day, were you? Okay. And Mr. Guy, you were, and you just gave a summary, correct? And we found we had jurisdiction. And referred it here, obviously.
Was there any other information that you wanted to provide?
No.
Okay.
I think it was fair.
All right, so then we should just move ahead? Okay, great. So we'll hear from the petitioner complainant first. You'll have 5 minutes for your opening statement.
Hi, my name is Sandra Weiss, and on November 27th, I submitted a public records request for the list of all registrants with all corresponding contact information who have registered with San Francisco's Office of Short-Term Rentals. And Kevin Guy, the director of the office, responded to me, and he gave me a certificate number, a street name, a street type, and a zip code. I replied and asked for contact phone number and email, and he responded that he could not provide the information based on definition section 41A.4 for short-term residential rental registry, which basically says that to the extent permitted by law, the department shall redact any permanent residents' names and street and unit numbers from the records available for public review. I replied and asked again for the phone numbers and emails associated with each registrant, as the ordinance only calls for redacting permanent resident names and street and unit numbers. Mr. Guy replied that we have, quote, "We have discussed the language and the application of this with the city attorney's office many times. Our practice is to not provide any identifying information about the host's presence on the registry or the application process that put them on the registry." I replied and asked for any documentation that demonstrates the city attorney's opinion. Mr. Guy replied the city attorney doesn't typically publish written opinions on individual practices of departments, and so on. You will see in the information I provided, I have made these requests of many, many, many cities now, and also the state of Hawaii have complied completely. You will see in your packet addresses, phone numbers, other identifying information. I can see that Mr. Guy in his response made the argument that the general rule, blah, 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 regarding, public records laws, individuals' privacy, general members of the public. But once you required these folks to register with the city of San Francisco, they forfeited their individual rights to privacy. They're no longer general members of the public. That's why other cities and the state of Hawaii have complied. But in spite of that, you're violating your own ordinance. Your own ordinance only calls for redacting the information stated, not phone numbers and emails. Also, Mr. Guy repeatedly asked me why I wanted the information, which is actually not permissible by law. So I'll stop there. I know there's time for rebuttal, but that is my case. If you have questions, I'm happy to answer them.
Just waiting for the clock to run out, unless you're done and you step away.
Oh, okay.
You just step away. Okay.
Awkward silence for 2.5 minutes.
Are there any persons or witnesses for any facts or evidence on behalf of the petitioner or the complainant? Seeing none, respondent, you have 5 minutes.
Thank you very much. Kevin Guy, the Director of the Office of Short-Term Rentals, which is a division of the Planning Department. Good evening, members of the task force. So I won't recite sort of the sequence of events as Ms. Weiss stated, but I will note that the language that was cited does come directly from Administrative Code 41A, which is the codified version of our short-term rental regulation. So I'll restate the pertinent sentence here. The registry that refers to the short-term rental host registry shall be available for public review to the extent required by law, except that to the extent permitted by law, the department shall redact any permanent resident names and street and unit numbers from the records available for public review. So I'd like to get to a part of the intent of that language is that the intent of the cited privacy protections is to avoid releasing identifying information about the host and the location of the associated short-term rental property. You may be aware if you go on a site like Airbnb, where you maybe map out and see the little pin drops of where short-term rentals are located, those don't actually correspond physically with the true address. So we've had many requests from the media for kind of they wanted to publish very detailed maps and things like that of the exact location of these properties, and we have responded by providing the quote what I would call the public version of the registry with the limited amount of data fields that Ms. Weiss referred to. So the intent of this is that is first and foremost for security reasons. So if you had identifying information about the host and the location of the property, an individual could locate the listing of the rental on a short-term rental platform such as Airbnb and identify a time when the property is likely to be vacant. This practice could enable behaviors such as burglary while the property is vacant. Mind you, I'm not alleging that's Ms. Weiss's intention here, but that's part of the reason why we want to keep this information constrained. In addition to the cited language in the short-term rental ordinance, the Good Government Guide published by the San Francisco City Attorney's Office provides further guidance on this issue. Ms. Weiss referenced it in part. The general rule is that department should not disclose home addresses, personal phone numbers, or personal email addresses of members of the public. Such personal contact information typically sheds no light on the operations of city government, and thus disclosure does not fulfill the central purpose of public records laws. Further, many individuals would not want their privacy, and in some instances, their safety threatened by unwelcome intrusions derived from public disclosure of their personal contact information. If the email address of a host is available to the general public, in the modern day and age, I mean, your email address could very well be a restructuring of your name, and it is a widely identifiable marker. So that email address could be used to find other identifying information about the host through general web searches, including their name, home address, personal phone number, the short-term rental listing itself, and other things unrelated to short-term rental activity. Hosts that have applied for the registry have provided personal information, including email addresses, but also things like credit card statements sometimes, tax forms, other things that obviously contain very sensitive data in an effort to prove their residency. They provided that information with the reasonable expectation of privacy. So such an expectation would be seriously undermined by the release of email addresses and other identifying information, particularly if the information were to be released en masse as requested by the complainant. I should note that one resource that is available for the public to identify specific properties in the presence of a short-term rental certificate but not identifying information is the San Francisco Planning Department's property information map. So you can click on an individual parcel and find out just sort of a yes or no whether or not there's a valid short-term rental certificate there. I do want to speak to the issue that Ms. Weiss had raised about my kind of further inquiries and the nature of the request. This was not an attempt to dissuade Ms. Weiss. This was actually an attempt for me to try to help her understand, if I understood a little bit more about the purpose of the information that she was trying to obtain, then I was going to sort of think about other ways we might be able to get there without violating those privacy protections. So I just wanted to be clear about that. It was not an intent to dissuade Ms. Weiss from her inquiry. So with that, for the foregoing reasons, I respectfully request that you dismiss this complaint. Thank you very much. Available for any questions you may have.
Thank you. Any persons or witnesses provide any facts or evidence on behalf of the respondent? Seeing none, members? Member Josh Wolf.
I've got a question for the respondent, if you could approach, please.
Mr. Guy.
Mr. Guy. So I just want to dig into a little bit about this language, to the extent required by law, except that to the extent permitted by law. And then we go through what is redacted.
Right.
So you may have gone through this in your intro and I missed it, but what is the exact either state code or city ordinance that you're utilizing for each of the redactions that you are that are part of this 41A.4, but it says permitted by law. So we need the backup citations to support what's permitted by law.
Right. So 41A, unfortunately, was adopted without any sort of reference to either prevailing sunshine and general public information request laws and laws that would also affect the ability to redact those. So we are, and quite frankly, this is a first for us here. This is a first in front of this task force, asking you to opine on this language, or Ms. Weiss is asking you to opine on this language, and by extension, we are as well. So I don't really have the full galaxy in mind of either federal or state law that may support or refute the ability to redact.
Sure. I mean, I'm not talking federal law at all. I don't think that enters this equation, but both just our state law and our local codes. The 41A may not have been written around the existing sunshine laws, but it wasn't composed in a vacuum. And so our existing local requirements say that when a redaction occurs, the onus is on the agency to cite which of the lawful reasons for that redaction there are. And so essentially I'm asking you to cite what lawful reason you feel that it allows to redact the names, the street, the unit number, the email, and any other materials that have not been turned over.
Certainly. So as I mentioned before, there were a lot of media requests initially when the regulations were first adopted around sort of seeing the entirety of the registry. So this was a topic that came up very early on and quite frequently with the city attorney's office. So in consultation with the city attorney's office, we were advised that we do have the ability to promulgate regulations. Yes, it's true that the strict language of 41A doesn't say you shall redact email addresses and phone numbers, or even say the credit card statements, tax forms, and other sort of information. But the underlying intent of the ordinance was to create a sort of severance between, giving sort of the entirety of the host registry out in a very public way where it could be disseminated. And inherent in that is a lot of sensitive data. The nature of the vetting that we do for applications, we collect proofs of residency, which could include things, again, the credit card statements cited, tax forms, things like that, financial statements, even medical bills. Sometimes we inform the person submitting that as their proof of residency. They're welcome to self-redact whatever they wish. But all of that, the city attorney opinion was that in concert with the straight language of 41A and the good government code language cited here, that the expectation is that the specific locations and specific identities of the host and the specific locations of their short-term rentals all kind of tied together as a collective piece of data. The intent was to not make that publicly available. I can't speak to other jurisdictions that Ms. Weiss referred to, such as the state of Hawaii, if they have similar thoughts or similar sort of concerns that ended up in legislation, but I can tell you that it was obviously a point of discussion when the Board of Supervisors adopted 41I.
So let me expand on this a little bit. So first of all, the Good Government Guide is not necessarily something we use or we follow. It wasn't created by us. There was no consultation with us to create it. We don't agree with many passages in it. And there's a lot of interpretation that's in there that we may not agree with that same level of interpretation. So what applies in this room is only the Sunshine Ordinance and not the Good Government Guide. And it's just a guide, okay? The second part is withholding is meant to be kept to a minimum. And that means there's a very high bar for redaction or withholding an entire document. We have gotten that many times. Most of the time it's from police department or from some law enforcement investigative unit or what have you, or some reasons like in the middle of a legal case or it's an RFP or something like that. There are very, very specific areas where things can be completely withheld and or redacted. But for the most part, as we're dealing with in Washington right now, the documents must be presented, okay? And if information on those documents are to be withheld through redaction or the, crossing out or what have you, whatever use there is to do that, you must cite specific law that allows you to do that. So, and I'll pick up where Member Josh Wolf did, reading from this very short paragraph that created the registry. It's the last sentence. The registration shall be available for public review to the extent required by law, except that to the extent permitted by law, the department shall redact any permanent residence name and street unit numbers from the records available for public review. So that's what we're asking for, is the law that allows you to do that. We might find that even though this is an ordinance that was it's part of the regular admin code, the question then becomes, does Sunshine Ordinance override that, or does it exceed that? And for the purposes of the Sunshine Ordinance, it's meant that all documents, everything is public, unless there's a citation as to otherwise. So I think that leaves us where we now have to determine at what level which part prevails. Okay, so with that, our 6726 withholding kept to a minimum clause provision says no record shall be withheld from disclosure in its entirety unless all information contained in it is exempt from disclosure under express provisions of the California Public Records Act or of some other statute. Information that is exempt from disclosure shall be mass deleted or otherwise segregated in order that the non-exempt portion of the requested record may be released and keyed by footnote or other clear reference to the appropriate justification for withholding required by Section 6727 of this article, which is a whole list of permitted information that could be withheld. So that's where we're at. Yes, Vice Chair.
Mr. Guy, you mentioned that in your preamble that in the past you've had many discussions with the city attorney. Are you referring to in the past when you were planning, or did you consult the city attorney specifically about this request? And if you did, how much of that would you be willing to share with us? And where I'm leading with this is if that city attorney could quote some applicable case law or something for us to kind of get into the meat of it, we might be able to do that. If you're going to claim confidentiality and it just that they advised me not to, that's not really going to help us.
Yeah, thank you for the question. I'm not claiming confidentiality. The discussions that have happened with the city attorney happened very early on in the formation of the Office of Short-Term Rentals. They weren't pertinent to this specific request, but we received so many similar requests that essentially the conversation had taken place, and the city attorney had opined at an earlier date that it was acceptable for us to create a public version of the registry that included only the certificate numbers, street names, and type of street, court, avenue, etc., and the zip code. Again, with the overarching intent of trying to avoid really drilling down to personalizing specific names and geographic locations.
And this is the first time that someone has taken it to this level and come before us? Okay.
Correct.
And no other like legal action compelling you to?
No, and I should make note of it. We've had several examples of receiving subpoenas for business records, where we do turn over the entirety of application files under a court order. That's typically in cases where you have our most common one is a landlord suing a tenant for conducting short-term rental activity without their authorization. We were not party to those suits. So in those cases, under a court order, we would release information, but it would typically be constrained just to one individual application or address or case.
Okay, and the one other thing I want to talk to before I lose the train of thought is the expectation of privacy. I do know, and I just took another peek at the OSTR application process. You actually have to register with the city as a business first. Mm-hmm. Once you get that BAN number, then you go online, and then you get into the nitty-gritty of all the tax records, vehicle records, all the really, I guess, personal stuff. There's a two-step process there, and I'm wondering, and I looked through all the language, I didn't see anything about your information being public, not being public. There's no language to it. So the reasonable expectation is not addressed in any shape or form from what I saw. And I'm wondering, throwing this out to the lawyers on the task force, the fact that it's a two-step process where you come in as a business entity first and then provide personal information to back up your application to OSTR, does that affect any our discussions?
Member Joshua?
If either of the lawyers want to respond, I'd be happy to hear from them before weighing in.
Well, go ahead, Matthew.
I think to step back, I mean, there is a statutory, and I think maybe I'll kind of know this, but the statute in the California Public Records Act definitely has a privacy exemption for an unwarranted invasion of personal privacy. And so, like, the question, obviously, that we're kind of dealing with is whether or not the request here is an unwarranted invasion whenever you've got people who are making submissions to the city for basically a license to do business. I don't know if I hope that's a fair kind of statement of what this is on the registry. If you're on the registry, you've basically received city approval. That's basically.
Yes, you receive city approval. It's an interesting type of business. It's a business that occurs within someone's home. So the general feeling of the public is that it's sort of an intermingling of the two.
And I just pulled down from, I guess, your office, the short-term residential rental guide from the San Francisco Business Portal, kind of answering a Q&A. And one of them does come up and say what information, one of the Q's, I guess, is what information is public, and in the A is there's a list of things, including, it doesn't specifically say email address, but it does say owner name of the business. Now that is, it is tucked in page 4 of a 7-page guide, but it is given out to the short-term rental applicants. So there is a little bit of notice that information could be private. I mean, we could also jump into the part where you're asking for approval to run a business of a special type. But then I also, when I look at the history of the 41A.4, I've looked at the kind of prior years. 2012, it did not reference the definition of basically this exception for deleting or redacting rather resident names and street and unit numbers. We have that language today. It wasn't in 2012. It was put in, it looks like, in 2014. And that started with names. And then 2015, they added names and street and unit numbers. And I hate to be too much of a stickler for like the text of the statute or the text of the ordinance, but the city has been in and tinkered with the provisions that should be, or the information that should be kept secret. And, email addresses obviously have been around, and I assume, and maybe you can answer, have email addresses always been part of the application process? Yes. I assume they have been. Yes. And what's, for me at least, what's kind of one of the critical things is that the ordinance does not address email addresses or phone numbers. I understand the argument about the intent behind, for all the reasons that you've mentioned, but it doesn't say email addresses and names. People who are seeking to be on this registry and do this type of business are on notice that at least their name should be, or as an owner name, could be public, understanding that maybe some people might do it as an LLC or maybe if they can, I don't know. But so there should be some notice that their information could be public. And those two types of information that's at issue here weren't mentioned and put in 2014, 15, or 16, and it's not in the current ordinance today when these concerns have probably, even if they've not been specifically identified, they've been surely on people's minds as they went through the ordinance.
Member Kate, I think you're referring to email and phone number, right? Those are the two that are not.
Yes, I'm sorry.
Okay. All right.
If I may respectfully, Member Kate, the reason, so the 2014 amendments to 41A actually legalized short-term rental activity for the first time ever in San Francisco.
Right.
So prior to that time, there would have been no registry that would have existed for legal short-term rentals that would have contained this information. Right. I wanted to make that clarification.
But the fact that it was then addressed again and revised to add, it may have been where someone in the city said, well, we're concerned about privacy. When we started out with this registry, we said we need to redact permanent resident names. And then in 2015, we said, right, also, and street and unit numbers, but no thought about the email address and the phone numbers, and nor was there was a slight tweak to this section in 2016 regarding creating the unique registration number, but it didn't get into the, we forgot about email addresses and phone numbers. And given that people are applying for a city license essentially to do business, and that they're kind of put on notice that this information could possibly be out there, that some public information could be out there as a business registration. It's hard for me to find that this would be an unwarranted invasion.
Member Josh Wolf.
I recognize you, Member Martin. I have something to say, but just let me get this out before I lose track of it. So, at first, just a theoretical, and I imagine that none of us may have the answer to it, but if we did a public records request on a list of all these psychotherapist business licenses in San Francisco, which is another business that people frequently conduct in their homes, I'm curious whether or not these same protections would exist in the first place. And if they don't exist, then the question comes down to, what is the law that makes these protections permissible, redactions of information permissible, which is what the law is written as describing, that if these privacy protections are permissible, they would be extended. If they're not permissible, then this information would need to be turned over. And when I asked Mr. Guy to provide the actual citations of the law that make it permissible, he didn't have that information handy, which doesn't mean that if he can't say why it's legal, it suddenly isn't, it suddenly becomes a public document. But it does put us in this interesting position without being able to walk through each of those arguments. And I'm not sure what the best path forward is there, because we could, on our end, identify them. We could give a continuation to allow Mr. Guy and his department to actually identify what those legal arguments are, but I feel that without manifesting and stipulating what the legal arguments for protecting this information that would otherwise be public, I don't know how to move forward.
Member LaHood.
So I just did a Google search on San Francisco data. There is a unredacted registry of businesses that has names, DBAs, street addresses, city, state. There's not phone numbers and email addresses, but clearly there are names associated with addresses, and some are, living trusts. And so I know this doesn't get to the emails and the phone numbers, but here's a situation where a whole bunch of people associated with businesses have addresses made public.
I will just say that the master voter file has almost all that information, and it's a public document. Member Martin.
Again, to kind of reiterate what Matthew was saying earlier, with statutory interpretation, we don't get to intent unless something's like not that clear. That's like your last step or last argument and analysis. And here it says resident names and unit numbers. If they wanted to put emails and phone numbers in there, they could have, and they didn't. LA's coughed it up, Las Vegas has coughed it up. I just don't know, just based on the plain wording of the statute, that you can withhold those. My big question would be is, I think Vice Chair Hyland brought it up earlier, is if the people who applied, it was on the application that said that wouldn't be provided to the public. And if that's not on there, I don't think there's a reasonable expectation that it wouldn't. They're applying for a business license with the city. I get it. I get why you're taking that position. I just don't think it's going to hold. And I would find violation.
So I'll just add that the Sunshine Ordinance is actually an enhancement of two state laws, the Brown Act for open meetings and the California Public Records Act. So we actually start with the CPRA, and the Sunshine Ordinance provides additional enhancements for the purposes of expediency and more transparency and efficiency. I just did a quick search for names, street, emails, phone, what have you, through the Public Records Act. There is lots of areas that are very specific, very extensive on withholdings. Nothing applies to this. What I'm also going to do is, just for edification so everybody hears it, it's a very short section of the Sunshine Ordinance in regards to justification for withholding. Any withholding of information, this is 6727, any withholding of information shall be justified in writing as follows. A withholding under a specific permissive exemption in the California Public Records Act or elsewhere, which permissive exemption is not forbidden to be asserted by this ordinance, shall cite that authority. B, a withholding on the basis that disclosure is prohibited by law shall cite the specific statutory authority in the Public Records Act or elsewhere. C, a withholding on the basis that disclosure would incur civil or criminal liability shall cite any specific statutory or case law or any other public agency's litigation experience supporting that position. And D, when a record being requested contains information, most of which is exempt from disclosure under the California Public Records Act and this article, the custodian shall inform the requester of the nature and the extent of the non-exempt information and suggest alternative sources for the information requested if available. Okay, so it's all of those. Okay, it's not or, it's A, B, C, and D. Okay, so that's what we're guided by for the purposes of this this case. Okay, so if you want, we can go start with A, and then but I think we should do that in. The question is, should we do that now, or should we hear rebuttals and then run through it? It's up to you.
I'm ready for rebuttals.
Okay, rebuttals? Okay. And then we'll run through it, and that'll help guide us for a motion, okay? All right. So is there any other questions for any of the parties? Do you have all the information you think you need? Okay. All right. So stay right there, Mr. Guy. You're going to be the first one to have rebuttal. You'll have 3 minutes.
All right, thank you. So yeah, I mean, I have not much more to add to the basic presentation. I mean, I will say that again, the ordinance was quite widely, or the topic, I should say, was quite publicly legislated. There was a lot of hearings on this matter. Privacy was a recurring theme that did come up. I would, and I don't say this glibly, but with all due respect, I would wonder if an adverse ruling here or a ruling in favor of the complainant would obligate us to release information such as, again, this I previously cited more sensitive information, task force, task force recommendation about an email address if it says, or task force decision if it says, well, the email addresses weren't cited specifically. Well, a lot of else that we look at in the purpose of vetting these applications thoroughly isn't cited either. So I'd be very concerned about the kind of creep on that. And the other thing I would say, and it's not for me to carry water for the short-term rental platforms, but I will say that they're, I believe pretty much universally their terms of service are, we only release sort of information to the government and by extension sort of make it publicly available when there are provisions in place, such as for taxation purposes, the remittances of taxes is very, very strictly protected by taxpayer privacy laws, et cetera. So we don't have quite the benefit of that scope of privacy built into our ordinance by explicit statement. But I guess I would respectfully ask the members to kind of consider the implications of kind of expanding beyond just the core of what the statement and the plain language of the ordinance is.
Just going to let the clock run out. It's your time. Okay, thank you. Ms. Weiss, 3 minutes for rebuttal.
So thank you again for hearing my case today and for existing in the first place. I think it's an important service that you provide, and I think that I'm just going to reiterate a couple of salient points. You made many of them when you spoke with Mr. Guy. So you're not following your own ordinance. It states very clearly, although I don't know that even that is legal. You all have cited other things that guide these kinds of things, but you're not even following your own ordinance. The subsequent argument that was made that in regards to members of the general public doesn't apply once you apply for a business license, as these folks have been now required to do with the state of San Francisco. They no longer enjoy the individual rights to privacy. It's just the way it works. And anyone who applies for a business license should have a reasonable expectation that any information they provide in terms of their contact information is now going to not continue to be private. I know that's the case for me, and your search showed that as well. And yes, you can find psychotherapists. Anyone who applies for a business license, you can get their information. Again, you have examples of many other cities, an entire state that have provided this information to me. I'm sure that they too have had the same kinds of concerns that you have, but sometimes the public's right to this information outweighs the concerns that Mr. Guy has raised, and that's why task force like this exists and laws like the ones you cited exist. So I continue to say that I made a request. I was never given a legal explanation or citation for why it was denied. I was on more than one occasion asked why I wanted it, and I ended up here today because I believe it is my right as a citizen in this country to have access to this information, and that you shouldn't break your own ordinances, let alone possibly other state regulations and legislation as well. So I thank you for your time.
Thank you. Okay, members, so I'm wondering if I could facilitate this and so that we could be, as sure as possible that we're covering all the bases, because we do have some specifics that we can, guidance from the ordinance that we can follow. Again, I did run through the California Public Records Act, and it talks about in-home supportive services and employees and state officials and law enforcement and all kinds of people with specific titles, things like that. Nothing in the realm of this. It does also talk about the master voter file, but it's up to local registrars to determine what they want to release and not release. And then the state has, a different set of of information with regards to the master voter file. They have a separate rule for that. Because I know here in our city we collect more information than what the state has on their master voter file. So the first one, a withholding under specific permissive exemption in the CPRA or elsewhere, which permissive exemption is not forbidden to be asserted by this ordinance, shall cite that authority. Has that been reached? Yes, no comments? Okay, we'll continue. B, a withholding on the basis that disclosure is prohibited by law shall cite specific statutory authority in the Public Records Act or elsewhere. That's an activity. Yep, Member Joshua.
Each of these requires specific citations, and we don't have the specific citation generated, so I'm not sure how this isn't just on the surface.
I'm just running through it so we can develop a proper motion.
Sure.
Okay, that's all. And that, if there needs to be some detail in the motion, that you have all the pertinent information. And I'll take whatever advice or counsel wants to provide to help guide us in this. C, a withholding on the basis that disclosure would incur civil or criminal liability shall cite any specific statutory or case law or any other public agency's litigation experience supporting that position. I don't think we've heard that, and I don't think the petitioner has reported not hearing that. And D, when a record being requested contains information, most of which is exempt from disclosure under the California Public Records Act and this article, the custodian shall inform the requester of the nature and the extent of the non-exempt information and suggest alternative sources for the information requested if available. Okay. So I think that kind of covers the scope of what what this case is about. Yeah. You guys, what do you think? Legal counsel? You have anything you want to add?
Well, I'm very sympathetic to what Mr. Guy is saying. I think it's a statutory interpretation issue. And I just don't see that names email addresses and phone numbers are in there. It's not. And I don't know if it was, they just assumed everyone would just include them in the statute. I think that's a dangerous assumption to make. And I think both sides agree that it needs to be decided. It's not, it's what is that statute?
Whatever happens here could possibly change, force them to amend the law. So
they could. That's how that works.
Let's give it to our legal counsel here.
So responding to Chair Wolf's question, going through the 4 subsections of 6727, it sounds like what you're really trying to get at is, was there a proper documentation of the reasons for the withholding? And it's the way I read these 4 subsections, particularly the first one and the second one is like, how specific does the citation need to be? Because Mr. Guy repeatedly in his email said, privacy concerns, the privacy of the applicants and whatnot, like to the extent that answering your question, you would have been more satisfied with citing the specific provision of the California Constitution. Is that what you're looking for? Or it sounds like that's sort of what you're looking for when you go through these 4 things. I just kind of wanted to make that observation because, and if that's what the task force is going to require, I think just to be clear about that and your interpretation versus whether the task force would be okay with sort of generally recognizing the types of reasons, like in this case, Mr. Guy, I don't think he's an attorney, whoever made the representations to the petitioner, didn't cite a specific provision. So I see the first subsection just says shall cite that authority, and the other one says a specific statutory authority. So just want to make that observation with respect to what you just said. And then I'm happy to comment on any other specific questions.
I would just answer that for other cases like the law enforcement cases that come in that they specifically cite penal code section such and such and such.
Yeah, I'm well aware of what folks usually do and what you guys are satisfied with, and just making sure you consistency and acknowledging that. So
That's why I was asking Mr. Guy if he had anything that he could
Yeah.
give us to get our teeth into it.
And I think
Hold on,
Mr.
let's-
Thorne also.
Yeah, just to be clear, I mean, I think that there are two distinct issues here. One is, did the agency meet the requirement of stating in writing the basis for withholding, versus the larger question, which also seems to be being discussed, which is whether or not it could be justified. And there's a narrow way of approaching the issue and a broader way of approaching the issue.
I think the two questions that have come up is what I'm bringing up and what Member Martin is bringing up with regards to what does the law that Mr. Guy is following, did it cite enough? Maybe they're collecting more information that they're not supposed to be collecting, in that way too, because the guidance of the way the ordinance was written only limits them to certain information that would be protected, so to speak.
The other thing that I wanted to add, I don't think was discussed as much in it, is the expectation privacy of the individuals who are submitting the information. And I think Member Kate was getting into that when he went through the application, and I was just sort of perusing the webpage as well. And I found information that said, only A, B, and C will be disclosed, nothing else will be. Like very explicit language on the Office of Short-Term Rental. Whether you agree with that or not, it goes to the expectation privacy of the people submitting information to the short-term rental office in the first place. Sure, you're voluntarily applying to be a short-term rental applicant, but in a way to become a short-term renter, there's a compulsory process of providing certain type of information, and the applicant is going through a thought process of, okay, if I provide this, where's it going to go? Right? And I think every balancing the privacy concerns, there are very few bright line rules because it's generally a balancing test with look at the specific context, look what the information is being sought for, look how the information was obtained in the first place, what sort of expectations of privacy were there in the first place, what's it going to be used for now. So it's hard to come up with bright line rules in that.
Where's that language?
Hold on. Member,
I also, as Member Loha did, I Googled Office of Short-Term Rental, and I mean, maybe I could send you the link, but it was just the application. It said information for applicants. You must register. And then I scrolled down a little more and it popped up, frequently asked questions. How private is my information? And something like that. So I might be off on, but.
So.
I don't know. Yeah. I don't know. Maybe.
Member Josh Wolf.
So I think that whatever communication the city may make about expectations of privacy should conform to the law. But I don't know whether if they say that you have privacy that isn't actually included within what the Sunshine Ordinance and the state records laws allows, that the fact that that this department said they wouldn't turn over that information, I don't think that makes it no longer a public document. I understand Member Martin's point about how the email addresses and these other information isn't explicitly mentioned and shouldn't be included. However, I'm not sure that the stuff that is explicitly included in regards to with the clause of if permitted by law is actually permitted by law, like the name and the address, because I don't understand how there is a legal difference between why this information would be protected and a psychotherapist wouldn't. I recognize that the law carved out this exception as permitted by law, but I don't see any evidence to support that exemption actually is supported by law.
Okay. All right. What shall we? So I think the sections here, let's see, that we would be looking at 6726 and 6727, but let me just see what the original complaints.
I would think that if there were to be a violation, it's because we feel like the justification's not warranted, not so much whether or not it was, and it could be that it's whether or not the justification was cited in the response. That's a separate thing. I mean, I would think that, and the point about the expectation, the expectation of what's being told to the applicants is something that is a wrinkle that makes it a little bit more complicated for the argument. But ultimately, I still believe that the ordinance says what it says. There have been opportunities
which ordinance?
The ordinance about what should be redacted.
Okay.
Thank you. It says what it says. It's been discussed. The ordinance does not specifically say, 41A4 does not specifically say that the information being sought in this complaint should be redacted. And ultimately, I think the balance between the expectations, between the public's right to know, the applicants for business licenses effectively, I think that right to know outweighs the maybe understandable discussions about whether or not intent should be found and where it's not written. And so I would say, and I think this is the appropriate section of the ordinance, that there is a violation of 6721B for failure to provide the records without a justification recognized under the ordinance or the California Public Records Act.
Is that a motion?
That is a motion.
Okay. Is there a second to the motion?
I'll second it.
So moved by Member Kate, second by Member Martin.
Just
Joshua.
I guess a question to the motion maker. Why does 6726 and 6727 not seem like appropriate violations?
It's a good point. I mean, I'm happy to amend the motion to add 6726. And
you almost have to include 27 because it says information that is exempt from disclosure shall be mass deleted or otherwise segregated in order that the non-exempt portion of the requested record may be released and keyed by footnote or other clear reference to the appropriate justification withholding required.
That's 6726. So, I mean, I'm in the motion to find a violation under 6721B and 6726.
And why not?
And why not 27? And maybe it's just I don't know. Was the basis of personal privacy not cited in the response to the complainant? I thought maybe it was.
The complainant said that she was given no reason, legal reason, no footnote, nothing.
All right. And I'll amend again to add 6727.
Okay. Is the seconder okay?
I'll second that as well.
Okay, great. So the motion is to find a violation of 6721B, 6726, and 6727. Anything else for the good of the cause?
I just wanted to ask the chair, if I remember correctly, I think we're not even allowed to engage in balancing, correct? The public's right to know versus the right to balancing test. We're not allowed to do that as a body.
I think that's right. I don't know. You have a strange look on your face, DCA Price Wolf.
Sorry for the strange look. I've never heard that. That's the strange look. When you say we're not allowed, I don't know what you mean. Like
as
the
far as
task
if we're,
force?
if we're determining something that's in the public interest or not, we don't get to do the balancing test.
That just sounds odd to me.
I know.
I don't.
There
that
is
doesn't
a
make sense.
provision. There is.
Right.
I'm going to try to look. There is a provision in the ordinance that says that no justification should be based on basically the balancing of
Right.
interests. Because that's a provision in the CPRA that talks about the weighing of the public. I think it's the public interest versus
That
it's
we're
in
not
here.
allowed to engage in it.
It's it can run up into some other issues, but it's definitely in there. I'm going to try to pull it up. It talks about.
Because this would be a lot easier if we could. I don't think we can.
Yeah.
I
know.
It's in there. I know it's in there.
It just sounds odd to me that if you're trying to determine whether you're allowed to withhold something based on privacy, which might require some sort of balancing, but then you're trying to make a determination where you have to make a black and white call.
Right. And
So,
I feel like
I'm happy to look into
I
that,
think
too.
I think it may be that there's the specific section in the CPRA that is a catch-all exemption, that is the balancing of interests, where it sometimes is used to, you can justify a lot of things, and it's used in that sense, where it's a specific statutory basis for balancing, as opposed to a specific statutory basis for withholding for privacy, which I think would have to necessarily involve some level of balancing. I think there's a little bit of a conflict between the ordinance and the CPRA.
Yeah, I'm happy to look into that. I'm curious whether what you're getting at there are some like mandatory withholdings versus permissive withholdings, but I'm just guessing. But I'm happy to look into that, or we can pause and look into it now. But
I mean, I actually do think that it would be good. I don't know. I don't think it's going to change my position on this. I think, admittedly, difficult one. But I do think that there are circumstances in the ordinance, the provision that I'm having really a hard time finding right now, but it's in there because I've thought about this conflict before, and I think it could be helpful to, and then maybe it's context specific, but to think about when there's that kind of clash between the ordinance saying that there can't be a balancing and then there being some balancing sometimes required.
well, I know referencing the Good Government Guide is taboo by some, but if you choose to look at page 117 of the Good Government Guide, it mentions general balancing and when that would be allowed and seen required by certain statutes and not. But I appreciate the task force opinion on it.
The only mention in the CPRA that I can find of balancing is with regards to video audio recording. That at least the word balancing or balance, as far as when balancing the public interests. But it could be described in some other way that I can't search for.
Member Kate, are you looking at maybe 67.1D about the right of the people to know, very few exceptions, that right supersedes any other policy interest government officials may use to prevent public access?
Sorry, what was that citation?
67.1D.
1D.
Kind of like the preamble part.
I think it's specifically mentioned in 6724G.
That's the one. No, it's I. And that's the balancing, the one in I, 6724I, that says there can't be a withholding based on a finding that the public interest in withholding outweighs the public interest in disclosure.
Yeah, all withholdings of documents or information must be based on an express provision of this ordinance providing for withholding of the specific type of information in question, or on an express and specific exemption provided by the California Public Records Act that is not forbidden by this ordinance.
But then we kind of come back around right where we sort of started, because the the CPRA specifically does exempt personnel, medical, or similar files that would, the disclosure of which would constitute an unwarranted invasion of public privacy.
But this is not that.
Personal privacy.
But this is not that. This is a registry for short-term rentals, not for anything else.
Right, but I'm saying that 6254C, which exempts basically from disclosure, you could say records that constitute an unwarranted invasion of public privacy, or sorry, personal privacy. I keep saying that. And how do you figure out what's warranted?
Let's be clear. It's not personal. It's personnel. Personnel. I'm reading it. Personnel, medical, or similar files, the disclosure of which would constitute an unwarranted invasion of personal privacy.
I still going to vote on finding a violation. I'm not going to back off from my motion, and I think this is an academic. I mean, I don't say this is an academic. It's important to kind of for us to grapple with, for thinking about this and for thinking about future cases. Similar files. I get it. I'm not saying I would like to make this argument on behalf of other people, but personnel, medical, or similar files. So what's a similar file?
Similar to a personnel record, which is protected. Okay, similar to medical, protected, HIPAA, what have you. This isn't that kind of file.
I agree.
Okay.
Just to be clear.
Yeah. All right. Okay. I just wanted to hear you say that.
I think I just want to make clear to Mr. Guy that I don't think we get to balance. So it's either it's a violation or it isn't. And
right.
That's that.
If I might, on the balancing point, though, I think that the important distinction in the relevant provision of the Sunshine Ordinance is that it's balancing the public interest of disclosure against the public interest in withholding, not privacy interest. It's public and public, and that's how it's distinguishing it from the CPRA.
I just have one more comment, quickly.
Yeah, go ahead, members.
I was just also looking at the Public Records Act, and there's actually there's a section N of 6254 in the Government Code, talks about things that are required by a licensing agency, and it actually talks about statements of personal worth or personal financial data required. So it actually talks about the specific, I think, scenario here. I think Mr. Guy brought up, well, maybe, credit card statements, and so that actually is covered as an exemption. Obviously, phone numbers and email addresses isn't part of that. So to just address one of the points you brought up, like the slippery slope type of argument.
Yeah, I understand. So, obviously the ordinance that was written here locally doesn't go far enough. It doesn't state inclusion, but it does talk about applicable laws. The question is did the respondent actually cite those laws for the requester?
Oh, right.
And that's what we're here to determine. I get what you're saying as far as what's applicable and what's not applicable. As far as what they choose to collect beyond the scope of what they're, it only specifies certain things can be redacted. Right. And that's, as Member Martin had brought up. One of the other things I just am going to throw out there is Prop B, the privacy first. There hasn't been any kind of provisions or policies that have come out for that since. So we don't know in the future if that will apply or not. But that usually only applies for city contractors, and the registry isn't necessarily, nor is any Airbnb. I don't think they can be considered contractors with the city. They're not providing a service for the benefit of the residents as part of a contract with the city, much like how the bike share program is in that kind of way. So I just wanted to point that out, that it kind of rings a little bit of that privacy first law, but I don't think that privacy first law would apply, because under Prop B would give the Board of Supervisors the ability to amend the Sunshine Ordinance for such purposes. So unless they want to, contract with Airbnb to provide the service, I don't think that will apply. So I just thought it would be worthwhile to mention that. Okay, are we ready? Okay. Any public comment? I'm sorry. Go ahead, Member
Through the
Knight.
chair. So if we find violation, are we going to send this to compliance and amendments to make sure that the complainant gets the emails and phone numbers?
You are the chair. Is that your pleasure?
I would think she wants this information.
Yeah.
Okay.
So I think that has to be part of the motion.
Okay. Do you want to make it part of the motion, or do you want me to just?
Through the chair.
Okay, great. Okay, so let's call for public comment other than the parties. There's no public comment. We're ready for a vote.
Can we read the motion, please?
The motion is to find a violation of 6721B, 6726, and 6727.
Okay. Thank you.
No.
It's through the chair.
Yeah.
Call the chair.
Okay, let's vote.
Aye.
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 Member Wolf?
Aye.
Member Wolf, aye. Member Kanata?
Aye.
Member Kanata, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes.
Okay, thank you very much for attending. Okay, let's get to the rest of our agenda, and
And I really want to thank you very much. I think it's an important decision, and I'm sure there's going to be more of it, but, we can't start this down this disparate road, so thank you.
okay, let's call the next item.
And, sorry, I gotta find my agenda. Ah, here it is. I got it. Next item number 10, reports from Sunshine Ordinance Task Force committees.
Anything to report from complaints? Microphone, please.
We had a committee meeting last week. It went fine. Fiona was there, and then
We heard from Ms. Lacey.
Miss Lacey was available by phone from New York in a hospital, and Member Yankee was there, so it was productive.
Okay, great. Compliance and amendments?
You
The only
You asked me to add ethics and sunshine training at the last Compliance and Amendments Committee meeting, but I didn't get any materials from you. You asked me to do that.
I did?
Yeah.
I don't remember.
What?
I have to think about it. So, the only thing I was going to talk about was the fact the other case for the Mr. Smith and FAMSF set up a schedule. He's receiving documents. He doesn't know if they're the pertinent documents that he really wants, but at least we have FAMSF giving him documents. And did we come up with an end game, like 4 months to go through everything? Or?
I think it was by July 1st.
Oh, by July. So that meant.
But also was the question of whether the other two organizations, how are they? Is information coming from those other two organizations?
Information is coming from emails between them.
For the committee?
Not from those other
Last item,
organizations.
Sandra Weiss versus Kevin Guy.
What about all the rest of the stuff he asked for? I mean, it wasn't just emails. He asked for all kinds of stuff.
Information, documents.
Okay, he's getting, okay.
Yeah.
Because, and also we should note that it made it into this case, the memorandum.
Thanks.
That the Board of Supervisors approved, that should be, since they submitted it, they should, we should apply it to that case. I think it was meant for the other case. So
Okay.
we'll have that information, and I believe you provided some additional information for that, for the other case too, right? Yeah, not the Arts Commission, the Fine Arts Museums. Oh, okay. Okay, great. All right, so we'll schedule that one, because I think we have everything now for that. And also, that was my mention for Mr. Nee, who mentioned that he actually was interesting. He actually, right after the case, he was here for something else, and he heard this case, and he just called him up and requested the memorandum. He got it the next day. Interesting. So then he forwarded it to me, and and so that was that. So anyway, okay. Anything else for compliance and amendments?
That's it.
Okay, great. EOT.
We haven't met for a while. We do have a meeting scheduled this month. Unfortunately, I realized that I am going to be out of town, so hopefully someone can fill in on the chair role. And I guess we only need 2 people, so if the other 2 members of the committee will be there, we'll be okay.
Sure to work it out. We'll figure it out if we need a third. Somebody can't make it.
Can someone volunteer now to do that?
When's the meeting?
The 21st.
Some people need a chair. Member Wolf has just said he's not available on that day. But can you review the agenda, please?
What's that?
Can you review the agenda?
I reviewed the agenda. Looks good.
All right, thanks.
I have to check my calendar, but I think I can share.
May 21st. Yeah, either way.
I can also do it.
Okay. It's got lots of backup there. Okay. Rules Committee.
I think you have before you. Is it? Oh no, it's not in the packet. Okay.
I sent you the minutes of the last meeting.
Oh, okay. I will look at those, and our stuff will get in the packet for next month. Okay.
And there's nothing for IT.
I don't believe there is.
One of the things I will mention about IT is I recently read that there's a company that was hired by the Mayor's Office of Housing Community Development called Exigy that created their Dahlia system, which is a pretty extensive online database, and they do that kind of work. I think they came out of the city's residency program for Data SF. I'm just thinking, I don't know, Cheryl, do you have any?
I don't have any information on that. All I know is it's been going on for like the last 3 years.
Eons. Right. So I'm just wondering if it might be a good idea for me to check in with them, since they're already contracted with the city. Maybe they have something off the shelf that they could provide.
Do you need Victor to give you information?
Sure.
Have Victor call you?
Sure.
Okay.
I was going to say I've interacted with them. They're very nice, and I think they will,
Okay, great.
worth talking to.
Okay. I will do that. Okay, next item.
I just heard from Victor, and he's right. I want to go back to item number 9, the Weiss matter. We referred it to committee, but we didn't say what committee.
I'm sorry, so to compliance and amendments.
The AC?
Yeah,
Next meeting.
as per the chair of CC.
Okay, great. Item number 11, Sunshine Task Force Chair's Report.
I don't have much to report.
I've gotten inquiries from the police department and,
From me?
yeah, the letters that were going to be written to the DA,
Oh, right.
supervisors
So
and all that.
that one, right. So for the police commission orders of determination, the letter to be written to the 3 agencies. I've been going a bit slow on that purposely, because I want to make sure that it's written properly, that it explains exactly what our intentions were coming out of that hearing. I inquired with Member Kanata as far as compliance and amendments with regards to that too. I think pretty much ready to go with it, so that will be coming. Okay. And you were notified by who?
Police
called?
department wanted to know what the status was, and I've also heard from Magic.
The police department?
Of the police commission.
The commission, okay.
Yeah, as well as Ms. Altman. Twice
Okay.
she's called me.
Yeah, Ms. Altman's contacted me several times, so she understands what the reason is. I
Yeah.
know she's chomping at the bit, but
Yeah, she is.
yeah. And would you guys like to see it before I guess I'll send you the draft of what we've been working on. Okay, great. That'd be helpful for us. Appreciate it. Okay, staff report. Next item.
Hang on a second, I gotta find it. No, I have that. I need the report. Item number 12. Okay, we have a schedule starting May 21 with EOTC and continuing through July 23rd with the complaint committee. Got them all lined up and scheduled. I've got draft agendas to Chair Wolf and Member Martin for both the EOTC and the complaint committee for this month, so they've both got those drafts. Complaints submitted about 10 business days ago, I got like 12 complaints on a Tuesday morning. And so I've tried to add them all here, let you know what they are. We've, since the 19037, gotten 3 more complaints. So it's getting pretty hot and heavy these days.
Okay.
Item number 3, pending petitions, complaints before the Sunshine Task Force. Just to let you know, as I know you're aware, Chair Wolf, of Ms. Lacey's, who used to be Ms. Trabeau, her name change.
That's the new name?
New name,
Yeah,
yeah.
Ms.
We found that out in the
Lacey.
complaint committee 2 weeks ago. She's changed her name. She has submitted 4 complaints, 2 of which she withdrew this week. So that's good news. So you might see last month's total pending complaints. Complaints filed by A. Lacey, Trabeau, 43 of the 71 pending complaints.
And so those are all being held at this point, right?
Well, we litigated one at the complaint committee. She appeared by phone. The Arts Commission was not available. They said they would not be participating.
She participated by phone under what pretense?
She said she was in a New York hospital recovering from back surgery. And I spoke with her later on this week, and I told her that if she wanted any more petitions heard before committee, she had to appear in person.
So okay, all right.
So I was at the complete committee, and correct me if I'm wrong, Chair Martin, we asked her if she was the same person as under her previous name. She confirmed that. We then asked her what prevented her from appearing in person. She then indicated she was in the hospital in New York, yeah. And so therefore she had asked for a phone appearance.
And this is kind of a question that I think we need to, I don't know how much in Rules Committee when discussing this matter, did you inquire with our legal counsel at all on any of this?
In Rules Committee, we did not know.
Okay. All right, so I think...
I can, but we don't have a lawyer at our disposal at the committee meeting.
No, but it was a request made or anything like that.
Oh, you mean for the Lacey item?
Yeah.
We don't. For her actual appearance by phone?
Okay.
I think she requested through Cheryl, right?
Yeah, she did, and it was timely.
Okay, yeah, okay. Because usually we don't we will make accommodations, ADA accommodations.
Yeah.
and-
Well,
and
I asked
see-
her if it was the ADA issue, and I didn't realize it was Ms. Chabot at the time
I
because she
see.
emailed. And then when her voice came up, well, what happened was my boss, Alyssa Samara, said, Ann Chabot's on the phone, and I went, aha.
It recognized her voice.
Yeah.
Okay. Okay. So, all right. Well, we'll deal with this.
Yeah. Yeah.
As we move forward, because this is an ongoing issue, and just in general, we have to kind of figure out what to do under these kinds of circumstances. So.
Just curious, since we're on the subject of the 22, I think, because I just put it away, the 22 outstanding complaints from 2017. How many of those are Ms. Chabot, Lacey?
Quite a few. I mean, the only 2017, I mean, we really don't have any open matters except for her.
Okay.
The same thing with 2018. I mean,
2019.
I mean, she's got 38,
2019.
I think, if my math is right, which is usually not, but if 38 38 complaints that we're assigning to her, and that's
yes.
Right. So I would suggest, I can't remember which one it is. I'll dig it out. We got a memo from John Cote, who's the public information officer from the city attorney's office. And he kind of laid out a case for us not recognizing these cases at all. It was quite rhetorical, I would say, the way it was written. I was kind of unimpressed by the presentation of the memo, because it didn't sound like something that City Attorney Herrera would write himself. I was quite taken aback by the tone of it. But nothing in there cited any kind of law. It was pure, perspective.
I don't think he is a lawyer.
But it was on city attorney letterhead, and it was signed. It wasn't a signature of Dennis Herrera, but it was typed at the bottom, Dennis Herrera, and then underneath it was John Cote with a signature. So and it didn't state at the beginning, this is my perspective or my view or anything like that. So I'm a little concerned by that document as to its legal efficacy, or whether it's a true legal opinion. And I'm going to be checking in on that. I think our legal counsel, I've mentioned it to DCA Price Wolf. He said he would take a look at it. I haven't heard back from him on it, but you might want to ask him for it.
When federal courts, for example, have established procedures for this, they've done it by statute, except for kind of one general common law bad faith thing, but the Public Records Act realm is one in which.
Yeah, the slippery slope for us is we allow anonymous complaints.
Oh, right. Well,
So-
the issue is the question of the name.
Impersonation.
Okay, that's that. Yes.
Yeah, it's the same physical person under multiple aliases.
Right. Mr. Price will mention that to me, and I did look at the rules surrounding that, or the statutory language surrounding it, and it does seem somewhat problematic. Or maybe it's actually on the website, where it even goes beyond just anonymity. But in any event, we'll
Yeah, if somebody wants to file a complaint as anonymous, they can. There's no reason for them to make up a name. That's right. And we've done it many
But
times.
just to be clear, so I understand what the letter you got from Dennis Herrera's office was. That was about this issue of a fictitious name? Okay, thank you. I
Yes.
thought it might have been about kind of vexatious litigation or something.
No.
Okay.
No, it was not about that. It was specifically about this issue. No. Okay. Anything else, Cheryl?
No. Pending petitions and complaints. The one matter that Ann Chabot has said to me a couple of times that is important to her is the very first issue, 17028. She said that's the most important case to her. Of all these cases that she's outlined.
And she stated that as Anne Trudeau.
Yeah, I spoke to her on the phone.
Okay.
That's what she said. And she reiterated it in an email as well.
When was this, though?
Like 2 days ago, like Monday, I think I got that email.
Okay.
Okay.
Pending issues.
Yep.
Those really haven't changed. Communications.
None.
No,
How's
that's
that
not true.
possible?
Because we got a letter. Well, this came in.
Have we fallen
Right.
out of favor with the public? Nobody wants to communicate with us?
This came in late Thursday afternoon, the day before I published the agenda. And it was directed to Victor from Eric Willett of the Enforcement Commission of the San Francisco Ethics Commission. And it is about, he suggested that this Christopher Seguin contact us about filing a complaint. Their decision was that there was no wrongful, there was an investigation done and there was no willful wrong conduct. They didn't find a problem, but it was suggested that this person go through us to see if there's a complaint that can be issued.
Mm-hmm.
That's what it was.
Okay.
So, and then the rest of that is about all the phone calls and emails that I have gotten over the last month.
Got it.
Pretty full.
Okay. Well, good work. Thank you very much.
The one thing that I do want to do is review with you, and I don't know if the rest of the committee has to be here, but different matters that are pending that we should probably talk about.
How many matters are pending?
Some of these go back to like 2016, Ray Hart's.
Oh, those, yes. Yes, I see those here. Those are waiting for other people to respond. Well, there's only three. One is the Data SF report, the Ray Hart's versus the librarian, and Mary Miles. That's the only ones I see here. Is there anything else?
This was prepared this afternoon. Mary Miles, Ray Hart's. Mark Bruno, I have a phone call into him because he keeps saying that he needs more time to gather more data. He's waiting for more information, and I want to know, does he want to pursue with the city with Sunshine or not? He keeps putting it off, saying he's waiting for information. And he's got a couple of issues.
I don't know. Those are pending cases?
Yeah, he hasn't told us when he wants to go forward before committee.
Well, then
It's not stuff we've heard already, right?
These were things that were, I don't know, let's see. Let's see, Mark Bruno, related to 190, it's got to be 17, 114, and 115, requested delay due to lawsuit. Push scheduling as it has already been delayed for a year. Contact and inform Mr. Bruno that if he doesn't schedule the matter for hearing within 4 months, the SOTF will consider tabling the matter.
okay.
That's what.
So the item's tabled,
Yeah.
right?
Okay. Yep. The Denta Tedeschi matters we've heard. Patrick Roddy. Scheduled for today, and he didn't appear. Bill and Bob Clark will be next month. Betty Mackey, David Tucker, already been heard. Betty Mackey, we're going to table.
Right.
Bob Clark will hear next month. David Tucker, we've already heard, and that's what Peggy was saying, that I guess Mr. Mulligan didn't tell the truth on the tape, so.
Mm-hmm. Well,
Okay.
they'll do what they will do.
I'm sorry?
I said they'll do whatever they
Yeah,
feel
they'll do what they got to do, so that's pretty much it.
Okay.
We just wanted to make you aware of what's going on.
Okay, there was one thing that you noted in here, file number 18, 1801
18022 and 18028. Those are Denton matters.
Right, those, but let's give it a little more context. These were referrals to complaints and amendments to monitor the petitioner's ability to enter City Hall with a service animal.
That was at our last meeting.
We heard those.
Okay, you did, okay. All right, was there anything to report about that?
We just reiterated the fact that,
Well, the Sheriff's Department came up and said that
The
they are
Sheriff's-
reviewing their policy, and they are going to train their deputies to
Right.
make it aware that when somebody says their dog is under control and they're not tethered, to, allow them access to the building. So they said it's going to take them a week to do that for all their deputies, for all their buildings.
Right, okay.
And we're
Oh,
gonna,
well, that's news.
Was
Yeah,
he
it
allowed?
is good news.
Was he allowed to bring his dog in?
so we're
tonight?
gonna keep.
he didn't
it-
have his dog in.
Okay.
Yeah, we're gonna keep it in committee until we.
Until we hear.
Sorry, we're gonna keep it in committee until we hear that he can access
Right.
City Hall
Okay,
with his service animal.
okay. Do you think we should have a monitor when he comes so we can observe? Maybe somebody, if he's on an agenda, somebody wants to go observe if he brings his dog?
But he hasn't been. I mean,
Yeah.
No, he hasn't.
He's
but-
been leaving his dog with a friend.
Yeah, I understand, but it's up to you if you're interested. Okay, anything else? Nope. Okay, great. Let's call the next item.
Announcements, item number 13, announcements, comments, questions, and future agenda items by members of the task force.
Anything, folks? I'll just state that I went to the PAR meeting in District 1. It was very interesting. I couldn't keep it organized because they were just asking me too many questions. And some of them were like, why do you think you need to do this or do that? And others were like, can I do this or can I do that? Or, that kind of thing. But I couldn't quite give the full thing. We need, I didn't get it in time, but we do have some literature, and we should get some of that printed out because it makes it a whole lot easier to say, okay, here's the whole gamut, read it, and now I'll take all your questions. But I really didn't feel like I gave them they didn't give me the ability to give them the full gamut of what we do in so many ways. So
Nick
anyway.
said it went well.
I from their perspective, great. Thank you. Appreciate it. I'm glad
No,
I
we
was.
appreciate you're going over to do that.
Okay. Yeah, it was cool. Very cool. Okay. Anything else? No. Last item.
Item number 14, adjournment. It is 8:24.
Well, we need a motion to adjourn.
Second.
Moved by Member Martin, second by Member Kanata. All those in favor, say aye.
Aye.
Opposed? We are adjourned. Thank you. Thank you.
So 2 hours in.
You okay when you were taking her out?
Yeah, she was fine. Just,
Oh my
Oh, yeah.
choose your spot.
Before everybody leaves, I have a question. You know what?
Sometimes you got to give her a little resistance. Lower down.
Yeah, very interesting.
One short of majority repeatedly.
That was the least
Never.
She's afraid. They're interested, or she's afraid that someone's going to see her.
All hell breaks loose.
Feels
Order
vulnerable.
cannot be followed.
When I take her out in the park, she wants to go like behind a bush or picking a tree.
Yeah, she kind of went near the bushes.
Yeah, I know.
I'm sorry, Cheryl, you were going to say something?
I just wanted to confirm who's actually going to be at the next EOTC meeting.
I will check my calendar.
Pansy, Highland,
I can do it.
and who
Oh,
else?
okay.
I'll do it for you. You covered.
Yeah, okay, yeah.
I got it.
Highland.
Cool.
That's 21st, right?
Yep, and who else?
4 p.m.
Yeah,
Who else is on the committee?
that's what I wanted to know. Who else is gonna?
Oh, do you still need another person?
No, you have there too.
Josh,
Who else is
Who are the
Josh is not gonna be here.
people on the committee at this point? We just changed recently, and I don't think we've had a meeting since.
It's on the website, right?
Can you turn off the mic?